mention for upgradation, my lord. My lord, sir.
Give your
Your Lordship, may I be permitted to mention on matter for upgradation?
give your
Lordship, I was praying for Lordship's kind leave to file and move a application for reimposition of interim order. Your Lordship was in session of this writ petition. When your Lordship was in hearing this matter, we preferred an appeal in connection to this matter. Your Lordship was pleased to grant us liberty, the petitioner's liberty, to approach your Lordship when the appeal was finished over. Yesterday, the appeal was heard by the Honorable Division Bench. The Division Bench has disposed of the appeal and directed us to pursue our remedies in the writ petition before your Lordship.
Where is the order of the division bench?
It has not yet been uploaded, Lordship.
After it's uploaded, mention it.
Great.
My lord, may I be permitted to mention for upgradation?
Give your slip.
My Lord, in respect of item number 241 on 70th, I have prayed for leave before your Lordship. Kindly remember, your Lordship has directed me to file the same and prayed for upgradation.
Lordship, I'm in person. You had you were kind enough to list. It was on default and it was again restored
Yes,
with
we have
your order,
restored.
and now it's for listing and so for the final hearing and the order.
Must have gone on its.
No, it's not there. So it's not coming on the list.
Take the slip. We'll see.
Much you are. Much.
ये होगा अपने नंबर पे चला गया होगा. हाँ. Yes, call out the. What happened today? Holiday.
First, I beg to appear on behalf of the petitioner. My lord, this matter, my lord, relating to the trade license.
Yes.
There was a my lord, jewelry shop. There are 3 partners.
Yes.
One of the partner, my lord, Gautam Adhikari, was died. Thereafter, the petitioners are the legal heirs of Gautam Adhikari.
Yes.
They made an application before the municipality, Memory municipality, to incorporate their names. And this, my lord, the kindly come to page 24. This license is valid up to 9th August 2025. My lord, since it is pending before the my lord, the authority concerned, let it be directed to my lord to take a decision regarding the incorporation of their names in the my lord, trade license.
That is, you have a dispute.
There is no other issue. I have annexed the copy of the my lord, the partnership deed. There is a my lord, kindly come to my lord, the page 13. Gautam Tapos Adhikari, and the Pratap Adhikari. There are 3 brothers.
Sir, as far as your private disputes are concerned, the municipality can do nothing about it. Resolve your disputes, then the municipality can do something about it.
This is my lord, the dispute over there.
So you resolve your dispute, sir. What can the municipality do? They can't do anything about it.
My lord, this is my lord, your Lordship is asking the dispute regarding the CRO like that.
Yes.
But they have not disclosed about the CRO, my lord, the regarding the disputes. My
Whatever
lord, my license is valid up to my lord, the 9th August. They have to my lord, after expiry, they have been given a chance to my lord, the contest before the my lord, the municipality, before the board of councillors. And lastly, my lord, that they have been replied by the RTI application. They have been made of RTI also. The RTI have come to the reply. This is my lord, come to page 24.
Page?
Page 24. Appeal petition under section 19(1) of the RTI Act dated as to such and such. That is online portal generated certificate of enlistment have been issued against the Tapos Adhikari, Pratap Adhikari, the partners of Manipur Jewelers by certificate number such and such. Secondly, updated online portal generated certificate enlistment after aforesaid name have been issued on 10th August 2022 and valid up to 9th August 2025 and holding premises number 647/614 according to the said certificate.
I have seen that, sir.
My lord, thereafter, my lord, they have been, my lord, taking the application before the through his lawyer. My lord, they kindly come to page 29. And since it is, my lord, the pending before the concerned authority to take a
You
decision.
are taking your name to be enlisted till the
Enlisted.
time your disputes are not resolved. You can't be enlisted as one of the partners, sir. This is your problem, not municipality's problem. So, you know, take your remedies to the relevant court, get it resolved, and go to the municipality.
As you lordship.
The petitioner the petitioners have preferred the present writ petition, comma, being aggrieved by the action of the respondent, comma, Memari municipality, comma, in not including their names in the trade license issued in favor of the partnership firm operating under the name and style of Monipuri Jewelers, MONI, you inverted commas mein kar dena, comma, which is functioning from holding number 647/614, comma, ward number 7, comma, Memari municipality, full stop. The case of the petitioners is that they are the wife and daughter of late Gautam Adhikari, comma, who was one of the founding partners of Monipuri Jewelers, comma, constituted through a partnership deed dated 21/1/2015, comma, along with his brothers, comma, namely, comma, Shri Tapas Adhikari and Shri Pratap Adhikari, full stop. The said partnership deed, comma, inter alia, comma, contained a stipulation that the firm would not be dissolved upon the death, comma, retirement, comma, or insolvency of any partner, full stop. It is submitted that Gautam Adhikari expired on 9/6/2021, comma, leaving behind the petitioners as his only legal heirs, full stop. Despite the firm continuing its business operation after the demise of Mr. Gautam Adhikari, comma, the private respondents have allegedly failed to either settle the state, comma, share, settle the state / share of Shri late Gautam Adhikari in the firm, or induct the petitioners as partners in his place, full stop. In his place, full stop. Further, the respondent municipality continues to issue trade license in the name of the said firm without including the name of the petitioners, comma, thereby prejudicing their lawful rights, full stop. Learned counsel for the petitioner submits that a legal notice was sent on 21/7/2023 to the respondent municipality, comma, but no action has been taken by the municipality, full stop. This court has heard the submission advanced by the learned counsel for the petitioner and has perused the materials on record, full stop. Upon examination, comma, it appears that the core grievance of the petitioner pertains to the alleged failure of the surviving partners to settle the estate of the deceased partner, or to induct the petitioners into the firm in any capacity, full stop. However, comma, such disputes relate to the internal affairs of the partnership and cannot be resolved by the municipal authorities, full stop. The issue of trade license by the municipality is based strictly on the partnership documents submitted before it and the municipality has no statutory authority or legal obligation to unilaterally determine or alter the constitution of a partnership or the rights of the parties inter se. Full stop. Since the petitioners are admittedly not signatories to the original partnership deed, comma, and no revised deed has been placed on record reflecting their induction into the firm, comma, the respondent municipality cannot be faulted for not including their names in the trade license. Full stop. The relief sought by the petitioner would require adjudication on factual disputes concerning the rights of legal heirs, comma, the continuation of partnership interests, comma, and settlement of accounts, comma, which falls outside the writ jurisdiction of this court. Full stop. In the light of the above, this court finds no infirmity or illegality in the action of the respondent municipality. Full stop. Consequently, comma, no writ of mandamus can be issued directing the inclusion of the petitioner's name in the trade license issued by the Mewari municipality. Full stop. Accordingly, comma, the present writ petition is dismissed, comma, with liberty to the petitioner to avail appropriate remedies in accordance with law, comma, for redressal of the grievances regarding succession, comma, partnership interest, comma, and settlement of any other accounts with the private respondents. Full stop. If your name is not there in the partnership, how can they be incorporated in the trade license?
Well, they have to prepare a face, otherwise they have not come to this court. Please.
They can't be added. Estate, EST.
This is my application. My lord, the corporation this is regarding, my lord, the security deposit. The my lord, corporation also, my lord, submitted this, my lord, statement that my client has received the principal amount. My lord, twice your lordship was pleased to direct the
Mr. Bandyopadhyay was supposed
There was
to
a direction to file affidavit, my lord. We have not been able to use an affidavit, my lord.
file an affidavit. Mr.
But there is no
Lord,
need because this is the
Either
corporation.
you were supposed to come with an instruction also.
Instruction I have taken, my lord. What they want to do, my lord, they want a
You consider the representation.
relegation before the commissioner for the security deposit
Correct.
part. Since they, my lord, obviously, my lord, they are not being able to, my lord, deny it on affidavit. So, my lord, let it be considered by the
My-
commissioner.
My lord.
But that will be respondent number, my lord.
That will be respondent number.
Two.
Because the principal amount has been paid, as has been
This is that is
submitted
there.
by my learned friend.
এটা নিতে পারো তুমি।
Mari Kagu.
The So the petitioner, comma, has preferred the present writ petition. Seeking a refund of security deposit for the work which is alleged to be completed by the petitioner
12 থেকে 17টা পরে করি
12 থেকে 17 আমি রিটায়ার করে গেছি।
In-
বলে দিয়েছি ওটা।
অন্য লোক আছে
alleged to be completed by the petitioner
আমি
under
retire করেছি।
Bidhanpur Municipal
তাহলে একটু
Corporation.
হাতে করে আস।
Bidhan
বিধান
Nagar Municipal
Nagar Municipal
Corporation.
Corporation.
Full stop. Your case is that you have received?
My lord, I have stated that. Principal amount I have received.
Page 7.
Learned counsel for the petitioner submits that a work order was issued on 1/12/2021 by the executive engineer Bidhan Nagar Municipal Corporation, full stop. In terms of the said work
Invited.
order, the
Crossing
petitioner
vice
had completed the work with full satisfaction. Full stop. The full satisfaction in May 2022. Full stop.
Oh, petitioner bhul gaye.
Learned counsel for the petitioner submits that they have still not received the security deposit which has been lying with the accounts department of the respondent corporation. Full stop. She states further that they had made several representations, but the same have not been acted upon. The bills have been cleared. Only security deposit.
Only security. My lord,
Bills have been cleared.
that I have already submitted before your lordship. Corporation has issued its certificate that entire payment has been made by corporation.
Learned counsel for the petitioner further states that she has received the payments regarding the completion of the work. Full stop. Her only grievance is that the security deposit which has been lying with the respondent with the corporation has not been paid till date. Full stop. Learned counsel for the petitioner at this learned counsel for the respondent states that he is ready and willing to consider petitioner's representation. Where is the representation?
So the representation is at page 16. 12th August 24.
Representation dated 12th August 2024. Full stop. In view of the statement made by the counsel for the in view of the statement made by the respondent, learned counsel for the petitioner states that she will be satisfied if the same is decided within a time-bound manner. Full stop. In view of the statements made by the counsel for the parties, comma, this court directs that the respondent number 2 shall decide the representation dated 12/8/2024 within a period of 8 weeks, 12 weeks,
8 weeks.
within a period of 8 weeks from the date of communication of this order, strictly in accordance with law, after affording an opportunity of personal hearing to the petitioner, by way of a speaking order. Full stop. With the above direction, the present writ petition is disposed of. No affidavits have been exchanged. None of the
Great.
contention.
So the work order date, my lord, will be 11th March 22. In place of that, in the pleading is a wrong date. Page 10, 11 March 22. Page 10.
22, page 10. Page 10.
In the pleading, it has gone down wrong.
11/3/2020. Pleading it's 21.
Feb. Para 2, there's a wrong pleading.
Work order issued on 11/3/20.
Wait, sir.
इसका ये लिख लो, मेमो नंबर यहाँ से डालो. This is 1108, right? Memo number just page 10. 1108, right?
My lord. 1108.
1108, right? /PWD bracket BMC. Date page. Dated. Yeah, mark it.
Grateful, my lord. My lord,
The other matters?
other matters, my lord, I have detailed from 12 to 17.
I have not. I'll come back.
These are only, this is only.
Only
It's
two,
only item number 2.
Okay.
only two.
12 to 17 again. I'll come back.
Grateful, my lord.
I am for the petition.
Well, I'm applying for
I am
state
for
of
the
West Bengal.
notified area authority. But I am filing my exception to the report filed by the notified area authority.
My lord, may I cut short the matter, my lord? My
Bol
lord,
rahi?
the issue is, my lord, the petitioners are not getting their gratuity and my lord,
Pension.
their pension. Now, my lord, these are admitted dues. I cannot stand in the way. Only thing, my lord, I am praying, my lord, that similar issue, my lord, has came up before the honorable division bench of this honorable high court, my lord. This issue has been dealt with and my lord, this order has been passed. If my lord kindly consider this and pass whatever order, I cannot say.
I do not know what is the contents of the order.
This is Bahrampur municipality, not the Kahipur municipality.
Yes, my lord. But the issue is same, my lord.
Same things.
But I don't know what is, I have not read it, my lord.
My lord,
Just,
kindly see, my lord, kindly come to page number, my lord, 5, paragraph 5.
Only interest.
yes, this is the interest part.
Interest.
It's only interest part.
Regarding the principal, nobody is denying that they are not entitled.
And also I have paid interest, my lord.
Only saying that, my lord, this proposition has been laid by a division bench. This can be considered by your lordship.
Okay.
তিনটেই copy আছে।
3, 4, 5, 6, 7, 8, 3 to 8.
It's only for the interest.
Yes, and my lord, paragraph 8, my lord. I am beseeching, my lord, kindly go through paragraph 8, my lord.
Who will pay the necessary grants? In the event the revenues from the property tax collected by board of members are insufficient to meet the gratuity due of the liquids and return.
Yes.
That is not possible. I am applying for
Well,
that
this-
is possible.
To my,
What is not possible?
Kindly paragraph 8 of the judgment. My
Yes.
land was referred. Din na bhai. না না আপনি আমার ইয়েতে দিচ্ছেন
It's an order, sir. It's an order which has been passed.
yes
Possible, not possible.
ah
You challenge the order.
no so far this matter is concerned not so far state of West Bengal is concerned only 40% of aid has been required to be given that has been allotted. I have filed a report in the form of paper. We have categorically stated in paragraph 5 it is that we have nothing to do more outside.
but my lord, this,
So that,
this is,
that is not possible. That is not your lordship.
What is possible, not possible is for the court to decide.
No, that is
All right.
he is just
We will see what is possible, not possible.
that
May I submit one?
Yes, Mr.
Petitioner is not getting my pension for the last 26 months, can you see? And also the gratuity, remaining gratuity is there. So, my lord, how they survive, my lord, this is the question, my lord.
report, sir.
18 থেকে 8.
Kindly consider my report. I have
Kindly
already
see.
filed.
But they
For
have
earlier
paid
occasion.
some benefits now 25 months, now 26 months, my lord. They are not paying. And gratuity, he has not got 1,30,000 gratuity is paying.
All right.
My
These
lord,
are pleadings are complete and
my lord, pleadings are
Yes, yes, we
complete.
have
Yes,
on the last.
yes.
The
I have filed
exceptions,
filed report on the last
exception has
occasion.
been
but
filed.
the same matter, my lord. Same thing has been related in all matters, 5 to 8, 3 to 8. Because I have made one exception because it covers all. Same, my lord, condition is made in other writ petition also.
No,
Same.
we have
Same ever.
we have not received any exception to the
give a
report.
copy of the exception.
But I have paid you.
আমি
I'm giving. But this is the copy.
3 থেকে 8
It's exception.
Attach.
It's a paragraph dealing only.
I'm doing this.
So Ramadan is night. I have filed report on the last occasion, madam.
Can you see the
So
report?
item 3,
Three,
4,
three.
5, 6,
6,
7,
7,
8.
8.
All pleadings are complete, right?
Yes, yes. Same matter.
Madam, you are appearing in 8, I think. 7. You have also filed your report.
Yes.
First one.
The same
series
thing,
of matters are-
same thing written, the state has said, my lord, that they have paid 40% of their, what they are
Yes, yes,
liable
so
to pay,
government
that
has
has
paid,
been
so
paid to the
allocated, so
municipality.
that is the report, same report in all the matters.
But my lord, your lordship knows, my lord, the pension and gratuity.
Heard.
But I am
Reserve.
giving it to your lordship.
CAV. All. Three,
my lord,
four, five,
only
six.
one thing, my lord. अच्छा, আপনাদের কিন্তু কেউ কেউ ইয়ে gratuity পেয়ে গেছে।
Full- please-
But only one thing, my lord,
Yes.
in the intergram, I have already given this sheet to the petitioner. Some petitioners have already get their
some-
gratuity.
Some,
So
what-
if this can be taken into
but
consideration.
one petitioner number,
Two petitioners, my lord, have already got their petitioner, my lord.
petition number
Pushpa
Pushpa,
Sardar.
yes,
That is my
Pushpa got
Which
gratuity.
item?
my lord, I'm supplying. the name.
Next item 4.
Item 4.
Item 4, Pushpa got gratuity, full
And
gratuity, my lord.
Kartik Chandra Das.
But
Yes,
he
sir.
has
Yes.
Item 4 and 7, my lord.
Seven.
4 and 7.
no,
4 and
7.5.
7, they have got,
They got their gratuity.
they have been paid.
Seven page?
Page, sir, আমরা দিয়েছি page।
Seven? কি নাম?
এটা হচ্ছে
কার্তিক।
কার্তিক চন্দ্র দাস।
এটা
ওটা pay করে দিয়েছে, pay করে দিয়েছে।
Asmat. আচ্ছা, copy দিও।
In 2 matters, they have got the gratuity.
Yes, my lord.
Pension,
Pension, my lord.
Pension.
All cases, pension is due, my lord.
Hold it. And petition number 4, 37 months pension is due, my lord.
Yes, my lord.
37
There are
months.
pensions are due. And my lord, my only humble
3
request
years,
is, my
1
lord,
month.
the judgment may be considered by your lordship, my lord. I'm grateful, my lord.
And also I claim interest thereof, my lord, because your lordship got the judgment of the judicial court.
I'm grateful.
Deeply obliged.
Deeply obliged.
Yeah,
Just keep it.
Grateful, my lord.
that's it.
My-
Anything else, Mr.?
Give it to lordship. Because
Have
I
got everything, no?
petition intended to get gratuity and pension. So when I am coming here for pension, and 2% man has got the pension fully, 4 and 7, and except that man,
No. 4 and 7 has got the gratuity.
only gratuity, not pension.
Not pension.
Not
Oh,
pension.
you said pension by mistake.
Not pension.
Grateful, my lord.
Deeply obliged, deeply obliged.
This matter. Oh, see, my lord,
CAV, CAV.
I have not heard.
I have to sit and
But I have not heard.
do all that.
My lord. My lord. Grateful of. But I have used one, I said one affidavit, Fonibhushan Chakraborty exception. But this
That's
cover all.
Today is connected matter day or what?
Yes, my lord.
All connected matters.
Lord, I beg to appear on behalf of the statement. My lord, in fact, my lord, the last occasion, my lord, my learned friend, my lord, submitted a report, my lord. This is my exception. My lord, I have already served the copy of the exception.
उसमें एक लाइन लिख लेना उसमें earlier matter में exception filed by the
Exceptional copy. तो
exception filed by the petitioner is
কোনো
taken on
report-ই দেন
record. ঠিক আছে?
ঠিক আছে। আপনাদের তো আপনারা তো সব করেই দিয়েছেন, ফরওয়ার্ড করে দিয়েছেন। আপনাদের তো আর কোনো পার্ট নেই। যা আছে ডিএলবি করবে।
Yes.
My lord, I am, my lord, submitting, my lord, in a nutshell, the facts of the case, my lord. My lord, the petitioner, he was appointed, my lord, in the year 1984, my lord, on 1/4/1984, my lord, he was appointed, my lord, in the post of road coolie, my lord. My lord, in the scale of pay, my lord, 220 to, my lord, 364. Thereafter, my lord, on 1/6/1985, his service was confirmed in the said post of road coolie. But since 1985, my lord, till the date of superannuation, my lord, he superannuated on 30th/11/2022, my lord. Till the date of superannuation, my lord, he received the entire benefits, my lord, the financial benefits, my lord, the salary, my lord, with my lord, ROPA, my lord, and as well as the, my lord, the CS benefit. CS benefits, lordship, the career advancement scheme, my lord. Only those employees, they are entitled to get the CS benefit, my lord, who are, my lord, competent and the efficient employee. He also received, my lord, 10-20 years, my lord, CS benefit. Thereafter, my lord, he retired from service on 30th/11/2022. Now, lordship, kindly see, my lord, just I want to show one document, my lord. my lord, last occasion I have submitted this document, my lord, on 11th April 2029, my lord,
28.
page 28, my lord. The director of local body asks the municipality, all the chairman, my lord, notified area authority, and the corporation, my lord, to submit a staff statistics, my lord, for granting, my lord, my lord, salary and DA, my lord. Salary, DA, etc. Accordingly, my lord, the municipality, my lord, submitted the staff statistics. Lordship, page 29. Page 29. And if your lordship kindly see, my lord, where, my lord, 310 vacancies posts are there, my lord, vacancy 203, and actual staff strength 107. Now, lordship kindly see, my lord, the next page, my lord, page, my lord, 32. 32 of the list. The municipality, my lord, send the staff, sanctioned staff statistics. Page 32, my lord, serial number 59, my lord. 15, Bhola Baspore, petitioner herein, my lord, road coolie, and approval order, my lord.
I've already marked it last time. You already mentioned it.
Yes. 59, my lord.
Bhola
Bhola Baspore, he is the petitioner. My lord, thereafter, lordship kindly say approval order dated, my lord, 378 post, and here the date of birth and his scale of pay is there, my lord.
Yes.
And he received the entire salary, my lord. I have annexed, my lord, his my lord, the bank statement.
Yes.
Now, my lord, after his retirement, my lord, lordship kindly page 35, annexure P5. The municipality, my lord, send his service book to the director of local bodies for approval, my lord. Thereafter, my lord, the lordship kindly see the next page, page 36. My lord, the director of local bodies, my lord, asks the municipality to return the DLB, my lord, return the service book and to resubmit the same. Why, my lord? As because on examination of service book, Sri Subhash Shastri and Sri Bhola Baspore, it is found that their profiles are not approved in ISMS portal of Buddhavati municipality. Considering the above fact, you are requested to submit the service book of Sri Subhash Shastri and Bhola Baspore after ISMS approval for verification from their end. My lord, last occasion, my lord, my learned friend, the municipality submits, he has already, my lord, uploaded the ISMS portal and forwarded the entire documents of the petitioner. My lord, now, lordship kindly see, my lord, after this thing, my lord was pleased to direct the state, my lord, to file a report. And
Report has been filed.
yes, report has been filed. In the report, lordship kindly see for a moment, my lord. Practically, my lord, nothing is there in the report. They have, my lord, annexed a fact sheet, or my lord, rather I say, my lord, a document. Lordship kindly see, my lord, they have annexed one fact sheet, my lord. Lord, if your lordship kindly go through the report, my lord, nothing is there. Only they are saying, as my name is not, I was appointed in an unsanctioned post. So this is, but this is completely, my lord, wrong submission, because, my lord, I have already, my lord, shown, my lord, that his appointment was made, my lord, against the sanctioned vacant post and within the staff strength of the municipality. Now, lordship kindly see, my lord, my exception. In the report, my lord, they are saying, my lord, no post of road coolie is there, my lord. Lordship kindly see, my lord, my exception, my lord, page 12. My lord, I have annexed here a document.
Yes.
Actually, my lord, this document was, these names have been, my lord, forwarded to the director of local bodies by the Buddhavati municipality, where from it reveals that, lordship kindly see, my lord, at least 10 posts of road coolie are there. And, my lord, out of these 23 employees, my lord, already, my lord, 10, my lord, they have retired. They have received their pension after approving the director of local bodies. And 10 employees, my lord, they are still in service. Now, lordship, out of these 23 employees, lordship, kindly see, my lord, for a moment, my lord, serial number 15, Olokde, from the said list, page 13, my lord, 13.
Yes.
Olokde, lordship, kindly see his designation, road coolie.
Yes.
Now, lordship, kindly see, my lord, after his retirement, due to non-payment of his pension, my lord, he filed a writ petition.
Yes.
Lordship, page 14,
Yes.
the order passed by
Yes.
Justice
Yes.
Shina.
Yes.
Thereafter, lordship, pursuant to that order, my lord, lordship, kindly page 17, my lord,
Yes.
Olokde, my lord, road coolie, they have sanctioned it, my lord, they have regulated this service. But, my lord, in the report, they are saying no post of road coolie is there. Only the technical mistake is this, my lord. To ISMS portal, my lord, has not been approved by the director of local bodies. Only this technical mistake. All along, my lord, I have received the entire benefits. Everything I have received. My lord, in one judgment passed by my lord's, my lord, lordship, kindly see that judgment. More or less similar order passed by my lords, my lord.
Yes, yes.
Paragraph 7, same thing, my lord.
Same thing.
Same thing.
Oh.
Actually, my lord, all these posts, my lord, under conservancy department, my lord. They are the conservancy workers.
149.
149.
Anything else?
No, my lord. This is my humble submission, my lord.
See,
My lord. My lord, all three matters are same, my lord.
I'll refer
one judgment I am relying upon.
Give, sir. Wait. Don't give it like.
WPA number.
No.
But I am giving the copy just within.
Yes, tell me.
WPA number 18159 of 2023.
Just a minute. WPA number?
18159
of 2023.
Just a minute.
Order
It's-
dated.
Say it again, sir. Don't, one of you.
I
One of 1-8.
18159 of 2023.
Yes.
The order dated mother
18,000 WP
5 to 2025.
Yes. Tell me. What is it?
Here
In
the
that,
honorable
Just a minute.
coordinate bench of this honorable court has held, Madam, I am reading. Granting retail benefits to employee in unsanctioned post would strain the municipality resources, negativity affecting its ability to provide public services. It would also set a precedent for other claims that could further undermine the municipality financial stability. Therefore,
But this is not applicable in the present case. You have already given it to the other person who similarly situated to him.
If your lordship
This is
directs
just
us, we'll consider it. If your lordship directs us, we'll consider it.
my lord, he is state, my lord. If the state considered, my lord, I think, my lord, municipality has no power.
Difficulties of the direct DLB. My lord, the fact is that there is no government order. We can personally pursue these persons to include uploading this portal. If your lordship
you
directs us,
give that judgment also.
Like here the petitioner, my lord, appointed, ওটা তো unsanctioned post ছিল। এখানে
Just take a printout from
পরে তো sanction.
হ্যাঁ, এটা তো
আমি দিচ্ছি।
my lord, that judgment, Honorable Justice Kaushik Chandra passed against unsanctioned post.
Do you have?
No, that judgment is not with me, my lord.
WPA number
But I have seen.
Not applicable, but
Yes.
deal with
Grateful, my lord, grateful. My lord judgment is applicable. Toto, my lord, similar matter.
February 2020.
And not only that, my lord, what I submit, my lord, out of that 23 employees, my lord, due to non-payment of pension, my lord, to file a writ petition.
So this takes care of 9, 10, 11, right?
Yes.
Nine.
Yes. I'm appearing on
9, 10, 11.
9 and 10, my lord.
So now there are categories, 149 ones, non-portal ones. So there are different categories.
Different
which
categories are
That is
there.
the reason I'm making it CAB, so that I'll make sure that which category it goes into.
My lord, the municipality admits that my appointment was made against the sanctioned vacancy.
We'll see that. You are similarly situated.
Similarly situated person. Grateful.
Great.
তো সরকার। With
Petitioners.
with Megha সরকার করে দিন, junior.
Just see if it's the same order.
yes
9, 10, 11.
9, 10, 11.
Which paragraph?
Last paragraph. Over to part.
इस ये file में. Just keep it in the file.
Grateful, my lord.
Grateful.
8, 9, 10 are same. 9, 10, 11.
Obliged, my lord.
Where's madam?
So this is another copy.
Yes, ma'am. Thank you. Affidavit in opposition, you have filed?
My lord, we have not filed. It is the same similar matter like item number 2.
Same.
Similar.
This, my lord, I am appearing for the corporation, my lord. This is
Yes.
same of item number 2, my lord.
All right. So these are also security deposits.
These are security deposit issue, my lord.
The rest of the payments have been made to them.
My lord, that is what it appears.
So why you are not releasing the security deposit or considering their representation?
My lord, let the commissioner consider, my lord, if. But today, my lord, the petitioner is not there.
She was here.
Yes, yes. In the morning, she was here, my lord.
Item 2 she has done.
Yes, my lord.
She's not there. Oh. She was making some statement, Mr. Nag, that she
Right.
might have withdrawn from these petitions, but she said she'll come back.
My lord, it might be that, might be.
You're saying something, I didn't. Just see if she's sitting outside. None for the petitioner. In the interest of justice, adverse orders are deferred. Let this matter be listed tomorrow. We'll have it tomorrow.
My lord. My lord, 12 to 17, my lord, is
12 to
all
17.
these things.
Yes.
With separate orders, my lord, because separate matters are there.
Yes, yes. All separate orders.
Okay.
We'll ensure,
Okay.
Mr. Nag, all separate orders.
No, my lord, these are separate, not for that, my lord. These are separate matters, my lord. My lord, there had been times we have assailed one of the matters to the Supreme Court at first, and once it is allowed, then we have assailed others. So if it is separate that way also.
What happened? You are appearing online yesterday also?
My lord, I am here in Delhi, my lord. I'm assisting senior Mr. Bandopadhyay for a few matters. I will be back tomorrow.
All right.
My lord, my lord. Oblige me.
My lord, she has not received the call.
Sorry.
She has not received the call.
All right. We'll have it tomorrow.
Oblige me.
I may not appear for the respondent number 6.
But this is the same matter,
Same,
Lord.
same.
I do not know, Lord, why they are probably do not want to proceed with the matter, because now the order of demolition is reinforced by a further inspection order. So long, at least, my lord, there was some ambiguity. They had some point that we were not heard. Now, my lord, if I think the subsequent inspection report is also
Dismiss in default. They are just avoiding us.
This matter would be the sixth attempt, my lord. Very fairly, my lord, to be sir.
and my lord, there is another
Just taking date and date and date,
Yes.
nothing else.
and my writ petition.
Dismiss in default.
My writ petition, your lordship will kindly ask the municipality now to enforce that order. So long, my lord, my writ petition was dependent on their writ petition. My writ petition is 9471 of 2025. I think that is item number 19.
I am, my lord, not a party to the writ.
Where are they?
Just my lord, senior friends.
Yesterday also they took time.
Yes,
Before
yes.
that also they took
They
time.
have taken time, my lord. Or lordship wants, my lord, kindly keep my matter day after or any day so that, my lord, they get one more chance. I can to that extent accommodate
Let's
them.
keep it on Monday then.
Very well, my lord. Kindly keep
Both
it.
the matters on Monday. Keep it on.
Kindly,
I'll just none appears for the petitioner.
No.
Even on the earlier occasions, the petitioner has sought time.
and they have not filed any exception to the report.
None appears for the petition. In the interest of justice, adverse orders are deferred. Let this matter be listed on Monday. Monday.
My matter.
Both the matters.
Again, my lord,
Let's give one more chance.
they are getting a lot of chance, my lord.
We'll see. Let's.
But they are just resisting only on the basis of, Lord, they have no documents. They are themselves saying that there is no.
Monday. We'll see that on Monday. We'll finish it off.
Lordship will record that
My
they have
lord,
not
indicate
used
this.
any exception to the corporation report.
My lord would be pleased to, my lord, indicate that there is a parentary chance, my lord, in the order. To that extent, my lord, kindly. my lord.
Let's be fair to everyone. You know,
We
Your
have
lordship
been-
has been more than fair. So many times, so many.
Monday.
Both the matters, my lord, will.
The second one is.
Yes, sir.
My lord, for item number 20, I'm led by Mr. Tondra Mukherjee. His paternal uncle has died. Today is Shraz ceremony. I'm paying for a day's accommodation.
My lord, subject to lordship's kind approval, but I am appearing on behalf of the municipality. I am short 15 days time for taking instruction of this matter.
15 days for instruction?
Yes, my lord.
Why?
My lord, it's a, my lord, unauthorized construction. My lord, I have to go for this.
Instruction, I can understand 1 day, 2 day for
My
instruction.
lord, the dealing officer, my lord, is sick, my lord. Who is dealing this matter, my lord?
Still, can't be 15 days. How do you know?
It is 7. My lord, 7 days time, my lord.
But 15 days.
No, next week. We'll have it on Tuesday.
Grateful, Your Lordship.
Not today, Tuesday. Learned counsel for the petitioner, the proxy counsel for the petitioner states that the main arguing counsel has suffered a proxy counsel for the petitioner states that the main arguing counsel has suffered a bereavement in the family. He prays for a short adjournment. Let the matter be listed next Wednesday.
Lord, the municipality may kindly file a report within the next week.
My lord, kindly, my lord,
You come back with the instruction next Wednesday.
next Wednesday. My lord, next Wednesday কত তারিখ হচ্ছে? কত তারিখ হচ্ছে দেখো?
Next Wednesday.
My lord, I am some different. 8 August. My lord, 8 August.
8th August.
8 August.
Well, Monday is a monthly list. So kindly keep it on Tuesday. Otherwise, my lord, if it goes down, my lord, it will be very difficult.
All right. Keep it for Tuesday then. That matter.
Tuesday, my lord,
Item 18. Keep it on Tuesday. Tuesday. 18 and 19.
18 and 19. my lord.
वो AKD को बता देना
but should retain its position, my lord. May please.
This is my affidavit of service, my lord. My lord, I am the adjacent owner of the land, my lord, where one unauthorized construction was going on. On to that effect, my lord, initially I wrote a letter under Right to Information Act. They informed me that there is a plan G+2. Now it's become G+5. My lord, I made a complaint before the appropriate authority, including the corporation, and also I filed a civil suit regarding encroachment of land. This is altogether separate. So in the civil suit, they admit that there are some unauthorized construction has been erected by the private respondents here, my lord. My lord, initially the corporation has issued notice, but thereafter nothing has been done to remove the unauthorized structure. This is my prayer. I have made representation. Last representation is my lord, page 38, 39, my lord, copy has filed. I believe my
the inspector in charge
no, in the last second page.
address ta to korbe.
Although I have given, and corporation has also taken cognizance, that is admitted
So
fact.
you have said nothing done.
No, but to remove the thing, page 14 is a letter of the corporation. 14, 14. Yes.
Assistant engineer in charge Borough department, building department is required to be made a party also here. Because if the allegation is G+2 to G+5, that is a serious allegation, but it is on the building department only. So now, my lord, I will have to take and will take. Will take initiate.
Commissioner has been made a party.
Assistant engineer, building department, in charge building department. He has not been made a party here.
That's okay, Mr.
Because Borough 1 has been made a party, Borough 1 is up to G+2.
That's all right. We will not go on the technicalities. Let the commissioner decide the representation.
My lord, as you. But he has to be made a party, I think. If your lordship desires that no, it not required, I will not.
Commissioner is overall, my lord.
Commissioner will delegate or is delegating.
Commissioner is Delhi.
Lordship, here is the police report.
Police has nothing to do.
Lordship.
What is the admitted position? That some portion has been unauthorizedly erected.
Portion if it is
Decide his only prayer is decide his representation. Decide his representation.
Very.
But if it is an allegation G+2 to G+5, it is dangerous.
Yes.
Yes.
Very much dangerous. I will have to take. Well, I don't know, but as I came to my knowledge, I will have to take.
You have to take what?
Action.
Absolutely.
Oh, absolutely.
Absolutely. Take down. The petition in the present petition is challenging the inaction of the respondent municipality in not considering the representations dated 14/8/2024 and 21/2/2025 filed by the petitioner, wherein he alleged the unauthorized construction carried out by the respondent number 5 and 6 at premises number 21/1/1A, Kolupura Lane, PS Mali Panchghora, District Havra.
21 to the one.
The case of the petitioner is that he is the learned counsel of the petitioner submits that he is the petitioner is the owner of holding number 101, Bazalpara Lane, Salkia, PS Mali Panchghora, District Havra. Full stop.
Mali Panchghora.
Petitioner alleges that the private respondent number 5 is the owner of the adjacent premise on which the unauthorized construction is being carried out. Full stop. Petitioner further states that the respondent number 5 entered into a registered development agreement dated 27/4/2022 with respondent number 6 for the purposes of developing the said property. Full stop. Counsel for the petitioner further states that the respondent had a sanctioned building plan for construction of a G+1, right? G+1 structure, comma, respondent number 5 and 6 are illegally raising G+4, my lord. G+4 construction.
3 extra floors.
G+4 building, comma, thereby obstructing the petitioner's access to free flow of air and light. Full stop. Mr. Mrityunjay further states that the petitioner had instituted a civil suit, a title suit number 274 of 2024 before the learned second civil judge, Howrah, wherein an interim order was passed in favor of the petitioner, while order dated 3/7/2024. Full stop. He further stated that despite the said interim order, the private respondents continued with the unauthorized construction. Full stop.
Sorry, take to wrap.
Learned counsel for the petitioner further states that the RTI application further states that the respondent had only granted sanction plan for construction of a G+1 floor, and they have been raising the additional floors illegally without any valid sanction plan. Full stop. Learned counsel for the respondent municipality states that they are ready and willing to consider petitioner's representation dated 21/2/2025. Full stop. In view of the said submission made by the learned counsel for the respondent, petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the statement made by the counsel for the parties, this court directs respondent number 2 or his delegatee to decide petitioner's representation dated 21/2/2025, comma, within a period of how much time, Mr. Banerjee?
8 weeks.
Within a period of 8 weeks, comma, from the date of communication of this order, comma, strictly in accordance with law, comma, after affording an opportunity of personal hearing to the petitioner as well as the private respondents or any other stakeholders, comma, by way of a speaking order. Full stop. With the above direction, the presented petition is disposed of. No affidavits have been exchanged. None of the contents are
Grateful, my lord. Act on the basis of the server copy, my lord.
from the date of communication of this order.
Act on the basis of server copy, my lord. Otherwise, I will certified.
Server gets next day only.
Great.
এটা আমরা করি সাইবার কপি এখন আর কি করে না
Deeply obliged.
My lord, I am for the petitioner. This is my administrative service. My lord, petitioner before your lordship became the unsuccessful bidder under Howrah municipality in the year 2023. But till date, he did not receive the earnest money. Though there is a condition, he will get the earnest money T+2 days. My lord, it is clearly stated in the page.
Where is the representation you have made before filing?
No representation not made, but I have
You
approached,
can file a writ petition without a representation.
my lord, kindly allow me to approach, make a representation to the commissioner, and he will consider.
Presentation should have been made.
Let
My
this
lord,
writ-
but there is a
let this be
specific
treated
direction.
as a
Yeah, but they should make a formal representation, we will consider.
No, let this be treated as a representation.
My lord,
We treat the writ petition then as a representation.
my lord,
The petitioner,
পরে আসবেন, পরে
আচ্ছা ঠিক ঠিক।
system তো আছে।
কিন্তু দুদিনের মধ্যে টাকা ঢুকে যাওয়ার কথা।
the petition, the
জানবে?
present writ petition
কি করে জানবে?
is challenging
থাকে?
the
কোনখানে আমরা
inaction
4
of
লাখ
the
টাকা deposit
respondent in
করেছি?
not
এটা তো representation
refunding the
করবে।
EMD,
অটোমেটিকলি
earnest money
থেকে
deposit,
আপনার মুখ
automated
that
procedure.
EMD amount
পায়নি, সে দুঃখিত লোক। একটা পায়নি, তাকে
even after
না
2 years of its deposit. It is the case of the, yes, it is the case of the petitioner that they participated in NIT number
मतलब page 11 column 3
2425.
my lord 2425 earnest money
In
is
NIT number
70
2425 issued by the respondent municipality. No, this is, no, the NIT number is this.
my lord money is 4,17,197 it is just second column page 11 my lord it is
They participated in the NIT number WB/HMC/TN/SE/18/22-23 dated 19/4/2023. Issued by the respondent municipality qua the work specified at serial number 3.
3
The estimated amount as per the tender, estimated amount as per the tender was rupees 208,59,850, and the EMD was 4,17,197.
97
That is the
earnest my lord that is acknowledgement in the page 29
takedown. The petitioner deposited the EMD on 12/6/2023 and participated in the said tender. Full stop. The petitioner qualified in the technical evaluation, however, on opening the financial bid, the petitioner was L2. Full stop. Hence, the tender was awarded to. Hence, the tender was not awarded to the petitioner. Full stop. Petitioner states that as per the tender condition, the EMD amount was to be refunded within a period of 3 to 4 days through automated process to the petitioner's bank. Full stop. However, even after 2 years, the respondent has failed to return the said earnest money deposit.
4 lakh
Full stop.
17,000
Petitioner states that he had approached the respondent for the refund of the EMD, however, it has still not been returned. Full stop. Being aggrieved, the petitioner has preferred the present writ petition. Full stop. Learned counsel for the respondent corporation states that they are ready and willing to decide petitioners. They are ready and willing to consider the present writ petition as a representation and address the petitioner's grievance within and are ready and willing to address the petitioner's grievance. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop.
my lord within a period of
Time-bound manner, wait.
Right.
Learned counsel for the, in view of the statement made by the counsel for the parties, this court directs respondent number This will be, madam,
The 8 weeks.
Commissioner.
8 weeks.
8 weeks. Respond number 4,
My lord.
superintendent engineer.
Superintendent engineer.
Respond number 4, to decide petitioner's grievance within a period, is directed to treat the present writ petition as a representation and decide petitioners and decide the same within a period of 8 weeks from the date of communication of this order.
My lord, I have
After
prayed,
affording an opportunity
I have
of
prayed for interest, my lord, since I have taken loan from the bank. Thereafter, I participated in the,
interest, I'm not sure about interest.
my lord.
After affording an opportunity of personal hearing to the petitioner by way of a speaking order with the above direction, the present writ petition is disposed of. I'm not directing them what to do, what not to do.
Grateful to you.
Affidavit of service is taken on record. No counter has been, no affidavit in opposition court.
Grateful to you.
Grateful, Lordship.
Yes,
My lord, I'm for the petition.
I have to beg to appear from street, my lord.
My lord, this is a matter relating to non-granting of sanctions plans. Non-granting of sanction plan. We have made the application. Now there is a system of the thing.
Who appears for the corporation? Which corporation? Which municipality? What?
Mahasthala municipality.
Mahasthala. Who have you served?
I've served them. From my opinion.
Give him the name of one of the lawyers for Mahasthala. Keep it for Monday.
Monday is monthly. We don't use
Tuesday. Take the number of one of the councils for Mahasthala. Tuesday.
My immediate services.
Give it back to him. Affidavit service.
Grateful. No, no.
Yes.
My lord, Mr. Bandyopadhyay is appearing for the state respondent, my lord. He's on his way, my lord. I'm praying for short passover, my lord.
Passover not possible.
And then kindly keep it not today, my lord. Then.
Who's appearing? Who's there for the state?
Mr. Senior Government Advocate Mr. Bandyopadhyay.
You start, let him come.
It's a family pension matter, my lord. The petitioner's husband, my lord, is deceased. My lord has joined in service in Joinaba Mudipur municipality in 1989 and retired in 2018, 31st January 2018. After retirement, my lord, he has not
31st January
2018. And due to on my lord approval of his service, he has not received any pension or pension benefit. After that, my lord, fourth litigation, my lord, government constant to give the post facto approval, my lord. Kindly see page number, my lord, 30.
30.
30.
Yes.
After post facto approval, my lord, it where my lord only certificate, legal year certificate from collectorate is to be furnished. My lord, I have submitted everything before DM, my lord, collectorate, but they have not received legal year certificate, and my lord, pension has not been settled till date.
So earlier also you filed one writ petition.
Fourth, my lord.
Yes, fourth.
This is fifth, my lord. My husband died on 2023.
All right. Take down. The petitioner, preferred the present writ petition, being aggrieved by the inaction of the respondent municipality in not sanctioning the family pension of the petitioner, petitioner deceased husband in her favor, even after 2 years of his death. Full stop. The petitioner is the widow of late Shri Sopan Kumar Das, who was an employee of the respondent municipality. Full stop. During his lifetime, he initiated writ petition number WP number 21576 W of 2016 for the grant of post facto approval for his post. Full stop. The said writ petition was disposed of by order dated 4/1/2017 with a direction to the respondent to take decision whether post facto approval can be granted or not. Full stop. The petitioner's deceased no, इसको ऐसे कर लो, post facto approval granted or not. Next कर लो, the reasoned order passed. The respondent, by order dated 6/2/2017, decided not to grant post facto approval qua his post. Full stop. The petitioner's deceased husband again filed writ petition number 6695 of 2017, challenging the said order dated 6/2/2017. Full stop. The said writ petition was allowed by order dated 17/5/2022. Full stop. However, the respondent failed to implement the said order, and hence the petitioner's deceased husband was compelled to file contempt petition CCP number 642 of 2023. Full stop. During the pendency of the said proceeding, Shri Sopan Kumar Das expired on 24/9/2023, leaving behind the petitioner and their minor son as his legal heirs. Full stop. The petitioner was impleaded in the said contempt petition. Full stop. The respondent, by letter dated 9/9/2024, decided to grant the post facto approval of the petitioner's deceased husband's post and directed the respondent municipality to take steps for the release of the family pension and other retiral dues of the petitioner's deceased husband. Full stop. However, till date, no amount has been released in favor of the petitioner. Full stop. Being aggrieved, the petitioner has preferred the present writ petition. Full stop. Learned counsel for the respondent seeks and is granted 2 weeks time to file the report by way of an affidavit. How much time? 2 weeks? 3 weeks?
3 weeks.
3 weeks time to file a report by way of an affidavit. Exception to the same, if any, within 1 week thereafter. List after 5 weeks.
My lord, kindly fix the date.
2nd September.
Faithful, Your Lordship.
Uh, 25.
25.
The non-payment of, my lord, the gratuity and pension, my lord,
And my lordship kindly.
What is this?
Lordship has called, I need an order, my
Put out
non-refundable
to-
JPF. So municipality has no objection, but only municipality has placed instead of 80, 12
Without the name.
Manada Jakir within a period of 8 weeks, only I have paid for 12 weeks. So all this process has been completed.
Take down. The petitioner affidavit of service taken on record. The petitioner has filed the present writ petition, comma, being aggrieved by non-grant of retirement benefits. This is all arrears of pension and all, right?
Area of pension also, gratuity and area of pension.
Has preferred the being aggrieved by the inaction of the respondent in not releasing the arrears of pension and gratuity, amounting to rupees 7,20,124, even after 9 months of his retirement. Learned counsel for the petitioner states that the petitioner was an employee of the respondent municipality and he has superannuated from the service on 31/10/24, right?
21.
Retired on?
Yes, retired on 31/10/24.
Full stop. He further states that his PPO was issued on 6/2/2025. PPO was issued on 6/2/2025, fixing his monthly pension at rupees 24,400 and gratuity at rupees 6,81,492. Full stop. 400, 6,81,492. Full stop. Subsequently, comma, the respondent municipality issued a calculation sheet on 3/3/2025, in which the petitioner's total outstanding amount is reflected as rupees 7,20,124, including arrears of pension and gratuity. Full stop. He states, counsel for the petitioner states that he has not received the payment despite making several representations to the respondent corporation. Full stop. When were you appointed?
My lord,
When were you appointed?
my lord, appointed, that I don't know, my lord, appointed in the year 2000, my lord. Most probably, my lord, actually.
These are the same as those which have been given the approval, 65 of them, same.
No, not same, my lord. This is exactly same as my learned friend submitted the, my lord, that order, my lord. Chota Arjun Nayak.
Learned counsel for the respondent municipality on instruction states that they shall release the gratuity amount within a period of, Mr.
Yes.
How much time?
12 weeks, madam.
Within a period of 12 weeks from the date of communication of this order.
My lord, my entry to
Learned
the
counsel
service,
for
my
the
lord,
petitioner states that he shall be satisfied.
my entry to the service 1st February 2000.
He shall be satisfied if the same is done within a period of 12 weeks as stated by the learned counsel for the respondent municipality. In view of the above statement made by the learned counsel for the respondent municipality, comma, this court directs the respondent municipality to release the said pensionary benefits, arrears of pension as well as gratuity within the time specified by them, i.e. within 12 weeks from the date of communication of this order. Full stop. With the above direction, the present writ petition is disposed of.
My lord, petitioner retired on 31st October 2020.
2020.
Yes, that I have not.
That I have.
Great.
Great.
Okay. Affidavit service taken under.
Affidavit service we kept.
ये सौरभ I'll come back.
I am for the petitioner. This matter, my lord, was pleased to take up, my lord, on the 11th of July and to direct Mr. Bhattacharya to take instructions. This is that sham cell matter in which demolition was directed to be carried out within 36 hours. My lord has by a reasoned interim order restrained that till day after tomorrow. Today, Mr. Bhattacharya is there with instructions.
Yes, Mr. Bhattacharya.
Two things, my lord. Admittedly, there are unauthorized construction. They could not produce the sanction plan. No, my lord, that is there. Now we have, my lord, passed an order, my lord, on my lord 7th December 2023. My lord, why, my lord, in 2025, my lord, they are challenging it, this, my lord.
Because they were in talks with you.
Lord, that is, my lord, neither here
You
nor
file your affidavit in opposition, deny everything.
neither here nor there. And my lord, very
You deny it.
very
Your-
clearly, my lord, a letter has been written. You find out the plan. And unauthorized construction against themselves, and it's my duty to find out their plan.
It was in Raniganj.
It was Raniganj. You don't have the plan.
No, I
File
have
your
the
affidavit in opposition.
Yes.
Or my lord, if so desires, can set aside everything, direct the corporation.
File your
Yes,
affidavit
let it
in
come on oath,
opposition.
my lord. Let it come on oath.
Let everything come on record.
Yes, on record, my lord. We don't know what will happen. For Mr. Bhattacharya's clients, I and my juniors, my lord, we had a field evening the evening before. We had to draft the writ throughout the night. So we had a great party. So thanks to his client in a different way. After so many days, months, if not years, we could all get together, sit at midnight, finish drafting at one go. There was no time to settle. So we got up at the wee hours and then we rushed. So in one way, my lord, it's been a bit of a deja vu for us.
He's always assisting people in the right
in the right way.
Take down. Learn and come for the respondent. Asansol
Municipal Corporation.
Municipal Corporation. Mr. Bhattacharya seeks and is granted 3 weeks. 3 weeks time to file his affidavit in opposition. A reply to the same, if any, within 4 weeks. Let this matter be listed after 5 weeks. Date.
Yeah.
2nd September. Interim order granted earlier is extended further for a period of 6 weeks. 6 weeks. Reply 1 week.
I am for the KMC, led by Mr. Debanjan Mukherjee.
Well, on the last occasion, your lordship was desirous of going through the order passed by the Honorable Learned District Judge, my lord.
Yes.
My lord, this was the application which was filed under the Trust Act.
This is the amalgamation one. Okay. Amalgamation.
Amalgamation.
Yes.
Well, lord, that is the application your lordship kindly sees. It is in respect of 89/1. And my lord, this is the copy of the order, my lord.
You purchased it.
But I'm the owner of 89. The pro forma is the owner of 89/1. Now, my lord, kindly see is pursuant to the order, my lord, I have ascertained the documents also that entire amount was paid to the Shebayats. Those documents are also with me, my lord. And my lord, all these documents were handed over when the amalgamation was permitted in the year of 2017. Now, in the year of 2025, my lord, they want to revisit an issue which has already been dealt with after going through all the records. And as a consequence of that, they don't allow me to pay the tax. The SSC number has been blocked, my lord. Kindly see page 46. I went to deposit the money, my lord. This is in respect of the SSC. Your lordship kindly compares it with page 40. My lord, kindly sees the SSC, my lord. It is in the left-hand side. And my lord, kindly takes up page 40, my lord, simultaneously. Your lordship will see the same SSC number, the amalgamated SSC number.
Yes, madam.
And my lord, one last document, my lord. I have been paying the tax. This is the record, my lord, in respect of the amalgamated portion. Same SSC number. But I have given one financial year. I have all the financial years with me.
My lord, kindly direct the petitioner to file up, praise these documents, all the documents.
No need, no need.
Before the assessor collector.
This
my
was
lord.
only for my satisfaction. You file your reply, you can't cancel it like this. You are nobody to cancel. You're not supposed to look into anybody's ownership and all that. That's not your job.
According to page 45, the assessor collector.
File your report, file your reply, we'll set it aside. This is not right. Bring your stand on record. Take down the petitioner has filed the presented petition seeking a writ of mandamus, directing mandamus or appropriate direction, restraining the respondent municipality from cancelling withdrawing or rescinding the amalgamation order dated 21/12/2007, whereby the respondent municipality had permitted the amalgamation of two properties, namely, premises number 89 and 89/1, Raj Krishnan Chatterjee Road, full stop. It is the case of the petitioner that he had purchased the premises number 89 Raj Krishnan Chatterjee Road by way of a registered conveyance deed dated 24/8/2010. Full stop. Subsequent to the purchase, the petition respondent number 7, who is the owner of the adjoining property, being premises number 89/1, jointly applied for amalgamation of the two plots. Full stop. The said request was considered and allowed by the respondent municipality, which passed an order dated 21/2/2017, granting permission for amalgamation. That's right. pursuant thereto, comma, the amalgamated property was assigned the new municipal identity as premises number 89 Raj Krishna Chatterjee Road, and the same is reflected in the relevant municipal records, comma, including the inspection register. Full stop. However, in the year 2025, comma, the petitioner received a notice of hearing from the respondent municipality in connection with review of the amalgamation order. Full stop. During the course of the said proceeding, comma, the petitioner was called upon to produce a copy of the order passed in miscellaneous case number 874 of 2010, comma, which, comma, according to the respondent municipality, comma, contained permission for sale of the property in question, comma, which is alleged to be Debatar property. The petitioner the respondent municipality by a letter dated 9/3/2013. No, what is the date of 25, right? 25. What is the letter?
Letter dated is 2/5/2013.
25.
25.
Addressed to respondent number 7, right?
7, and a copy was given to the petitioner also.
Stated that the competent court stated that as per the competent court, the property, the Debatar property, could only be sold subject to condition that the entire sale consideration must be deposited in the name of the deity. Full stop. Respondent further stated that unless satisfactory proof of such deposit is furnished and the court's permission is placed on record, comma, the amalgamation would not be treated as valid. Full stop. The grievance of the petitioner is that the amalgamation was duly permitted by the municipality in the year 2017 after full consideration of all relevant materials without objection or requirement of any further documents. Full stop. No reference to the alleged status of the property as Debatar property was raised at the time of passing of the order of amalgamation. Full stop. Counsel for the petitioner contends that after a lapse of 8 years, the respondent municipality is precluded from revisiting the amalgamation order or imposing any fresh condition. Full stop. Fresh condition or imposing any condition, particularly in the absence of any fraud, in the absence of any allegation of any fraud. Full stop. Fraud, misconcealment, or material concealment. Fraud, misrepresentation, or material concealment on the part of the petitioner. Full stop. It is further submitted that the petitioner had acted in a bona fide manner and in accordance with law at all material times, and that the action of the respondent is to unnecessarily harass the petitioner after a prolonged period of 8 years. Full stop. The municipality, it is contended by the counsel for the petition that the municipality had the opportunity to verify the ownership and title documents at the time of granting of the amalgamation order in the year 2017. Full stop. No such objection was raised by the corporation, by the municipality in the year 2017, and the property was treated as a single amalgamated holding in the municipal records. Full stop. The sudden issuance of notices after such prolonged delay is arbitrary, unreasonable, and contrary to the principles of natural justice. Full stop. The petitioner further states that there has been no misrepresentation or suppression of material facts while seeking amalgamation. Full stop. The municipality, acted upon the amalgamation and having altered its record accordingly, cannot be permitted to undo its own administrative action to the detriment of the petitioner, particularly when no fault is attributable to him. Full stop. In view of the above, the petitioner states that the respondent municipality shall not take any coercive steps in furtherance of withdrawal of the amalgamation permission dated 21/2/2017 in the absence of any cogent grounds supported by law. Full stop. Learned counsel for the respondent municipality seeks and is granted 4 weeks time.
Yes, my lord.
4 weeks time to file affidavit in opposition.
My lord, kindly dispose of the matter.
But I think
Without
report-
reply, it can't be disposed of. Without reply, I have to take your stand, then only I can dispose it off.
but for the time being, may be permitted to deposit the tax
The tax, I'm not getting into this.
because they have locked the SSC.
Allow him to deposit the tax at
Just
least.
to pass an order because they have already kindly
Kindly direct
You have,
assessor
you have,
director.
you have not asked for it.
but I have prayed for an interim.
You have
order.
not asked for it, sir.
But I didn't.
You have not
kindly
asked
take
for
the
it.
prayer G, my lord.
Yes. That is not here, not there.
But I have sought for my lord. So
I can verbally tell them,
My lord,
allow them to deposit the tax.
my lord, only direction, short direction upon
Not
the
for
that.
tax. Tax, I can't give a direction. That is literally allowing them the amalgamation. We'll consider it and seeks and is granted 4 weeks time to file affidavit in opposition. Reply to the same, if any, within
1 week.
1 week thereafter. List after 5 weeks. In the meanwhile, the respondent municipality shall not take any steps for cancellation of the amalgamation order for the premises in question. Amalgamation order dated 21/7/2017 for the premises in action. For a period of shall not for a period of 6 weeks. ठीक? Or until further. I give it back. You take it back. I just wanted to have a look at it. You can't just cancel your own decision after 8 years without any ground.
I think some documents are not in the
What
file.
gives you the power to do it, madam? You show me under which provision of law you are cancelling his amalgamation. Where is the power granted to you? Which section have you invoked to cancel it? Once you have granted him the amalgamation, after duly being satisfied, how can you cancel it? Where do you have the power? Where does the commissioner have the power to cancel? Where is the power to cancel?
177.
178.
What is the misrepresentation? You will look into a judgment and decide what is the condition in the judgment.
I have no instruction about this, why the amalgamation.
The reason is you started this proceeding only because you want the receipt. Who are you? You have become technical experts.
This is 170.
I know there is no, I've seen it. You don't have a power to cancel. Next.
Look, here, the petitioners are all milk sellers. Now, there are 370 milk sellers, and they're having a cow shed at under Dankuni municipality. Earlier, they were all based in Calcutta. Now, after 90s, they were asked to shift from the Calcutta because there was some pollution and congestion in the localities. So slowly and gradually, they moved to Dankuni. They started buying land. So the cattle shed owners are maximum having their own land at Dankuni. Now, this land is near a canal which flows into the river Ganges. Now, we were running the business from 1993, 1994 there, selling milk to different people. Around 2.5 lakhs consumers are there who are taking milk from us. Now, recently, what happened that one NGO, who is the respondent number 16, he files a case before the National Green Tribunal. And the ground of the case is that because of the defecation and the cow dung, the canal is getting silted. So it is getting blocked. So it's going to affect the canal. Now, the National Green Tribunal passes an order. Lordship will just kindly come to page. It starts from 48 to 61, but the better page is Lordship, page 138. 138. Annexure to my year. This order starts from page 48.
Page
48. But since because these are the stamp and everything is just not very clear. So, Lordship, I will request your Lordship to kindly come to page 138. This was annexed with the civil appeal in the Supreme Court. Now, if you see the order, in this matter, there are 12 parties, but none of the milk seller or anybody who represents the milk seller, they were made the party in the proceeding before the National Green Tribunal. We were not the party therein. Now, the court passes the order. Now, Lordship may kindly see the important thing I would like to show from paragraph 6 of the order. Affidavit dated 2nd November 2022 has been filed by the district magistrate and collector Hooghly, respondent number 9, where it is stated that the Dankuni Badyavati canal from 0.00 CS to 229 CH passing through many wards of Dankuni and Badyavati municipality is being maintained by the Irrigation and Waterways Department, Government of West Bengal, but the same has been presently silted up, especially from 29 CS to 339 CH, and the said canal has been compacted and totally filled up with cow dung. A proposed solution has been given by the district administration at page number 44 of the paper book, which are read as hereunder. Now, the solution is here, dung collection. This is very important, Lordship. As per the site investigation, the farm owners are ready to collect and hand over the dung to a collection system, 4 SG NGO operated collection and primary processing center can be planned. So we agreed, we said, these are the farm owners, my clients are there, all the milk sellers. Now, thereafter, the other solutions are there, collection, everything is there, maintained. Then, apart from this proposal, the proposal came from the Pollution Control Board also. Start from paragraph 11 of the judgment, page 142. Now, what you will see from the bottom of that page 142, it has been mentioned during the discussion with representative of the Dankuni municipality that more than 200 canal sheds now exist in the stretch of land. The number of cattle present in one shed is more than 40 or more. Hooghly district is famous for dairy products, but neither the officials nor the persons met in some of the cattle sheds could provide any specific information about supply point of the milk product produced in this cattle. And then there's the remarks. Cattle dung is a steady source of biogas. Because of its methane content, proper anaerobic digestion of cattle dung can turn these huge waste to useful fuels like biogas, etc. However, steps like proper estimation of number of cattle sheds and organic load available from these cattle sheds, establishing collection and management system for collection and transport of this cattle dung to a plant for anaerobic digestion, efficient plant operation, and setting up supply chain for cleaner fuels generated in such plant, sealing of the pipes which are directly discharging to canals once altered disposal system starts functioning are expected to transform the environmental condition. So this is Pollution Control Board, Lordship. Now, thereafter, the Central Pollution Board also in paragraph 13 gives the suggestions and proposal. Here also, the Central Board gives the analysis and finding and also suggest for this biogas and briquettes. Now, paragraph 14 is the National Mission for Clean Ganga. This is the party there. They also give the proposal, Lordship. I'm just cutting short. Page 147, Lordship, will come to paragraph 15. In the affidavit is further stated that industrial pollution from grossly polluting industries, that is Dankuni Coal Complex, Bengal Beverages Private Limited, Mother Dairy Plant, and vehicle workshops are also contributing effluents into the canal system. Just can you note down this thing, Lordship? We are only a milk seller having a cow shed, Lordship. We are all maximum illiterate poor people. The Pollution Control Board also give the details of the other big industries that they are also contributing to the pollution. Now, the district magistrate in paragraph 16 has given a proposal. The district magistrate and collector Hooghly has filed further affidavit stating therein that by letter dated 7 December 2022, he has requested the chairman, Dankuni Municipality and sub-division officer, Sirampur, to take further steps to stop dumping of a cow dung in Dankuni Canal. It is stated that another letter dated has been written to the member secretary, West Bengal Pollution Control Board for sanctioning rupees 76.15 crores for construction of proposed biogas plant in the area. It is also stated that a further proposal has been received from the chairman, Dankuni Municipality, for installation of briquette making plant from cow dung by latest such and such, which is mainly related to clearing of Dankuni Canal. So everybody is giving proposal. You should give a biogas plant, you will have a briquette, the government authorities. Then what happens? Can you see the unfortunate part on my part? Now what happened here? Now direction is passed. Now Lordship, we can see paragraph 18 onwards. We therefore direct the excavation of Khal Canal be completed by 31st March 2023. Not done. Affidavit of compliance be filed by the district magistrate and collector Hooghly by 15 December 2023. As per my instruction, not done. In the affidavit of the district magistrate and collector Hooghly, it is further stated that a detailed project report has been prepared for setting up a biogas plant for 76.15 crores, and the ARD department had visited site and prepared for the DPR, and the land measuring such and such has also been identified. Then another affidavit, paragraph 21, by the chairman Dankuni Municipality, where he proposes to use for dewatering a briquette making plant from cow dung. So there has to be a cow dung. The cow dung will be used for the purpose of biogas and also for preparation or manufacturing of briquettes, Lordship. Paragraph 21. Now the order is passed. Paragraph 22. From the documents on record, we find three main projects need implementation for restoration of the Dankuni Canal. Number one, completion of dredging desiltation of the canal, which is stated to be completed within 180 days from the date of work order. Therefore, we expect the same have to have been completed by 31st March 2023. Till date, as per my instruction, not done. Since land has been identified, and the DPR of the same is also prepared, we direct the state administration to take up the matter regarding final approval expeditiously for setting up the biogas plant within a period of 6 months, that is by 30th November 2023. Now 3, we further direct the plant for making briquettes from cow dung be expeditiously considered by the Urban Development and Municipal Affairs Department, Government of West Bengal, and appropriate orders be passed in this regard within 1 month. Then 4, where now have been affected. We further direct that the state administration, Dankuni municipality, with the help of police authority, shall remove all illegal khatals, cow sheds, cattle sheds from the site expeditiously in accordance with the law, preferably within a period of 6 months by 30th November 2023, and file an affidavit. Now, this is the 4th part where I've been affected. Now, after the passing of this order, Lordship, there is one trust, name is Manoharpur. Now, most of the members of the cow shed owners, they have been made a member therein. Now, after the passing of this order, the Manoharpur went to the Honorable Supreme Court in an appeal. Lordship, you kindly see page 93. Annexure P4, 93, Lordship. The cattle milk shed has not gone, but this organization, Manohar Milk Project Association, this one association, a trust form with, as far as I can understand, the trust cannot have that locus. But anyway, they have gone there. They have challenged the order of the National Green Tribunal. Now, Lordship, the Supreme Court has modified the order of the National Green Tribunal by saying, as stated in order dated 11 September 2023, there is no reason to interfere with the direction contained in clause 4 of the paragraph 22 of the impeachment or judgment. So 1, 2, 3 remains. Direction upon the state government. 4, however, while implementing the direction issued to the respondent number 10 and 11, a show cause notice shall be served upon the persons likely to be affected by the demolition of illegal structures in terms of clause 4 of paragraph 22 of the impugned judgment. After giving a show cause notice, the concerned person shall be given an opportunity of being heard. After hearing them, if the authorities are satisfied that the structures are liable to be demolished in terms of the impeachment order, an order to that effect shall be passed, such and such, Lordship. This was the order passed by Honorable Supreme Court, Lordship. Thereafter, 105 is the first demolition order. This order is dated 16 February 2024. This order was passed. Through the show cause letter, you have been given opportunity to be heard. Through this show cause letter, you have been given opportunity, but there's no hearing taken place. Now, when this order is passed, the Manoharpur files and take out a contempt application before the Supreme Court. That is page 106. We are not satisfied that a proper opportunity of being heard was granted by respondent number 10 to the appellant. We direct the representative of the applicant to appear before the chairman of the respondent number 10 or such and such. After opportunity of being heard, the respondent 10 will pass an order, fresh order in terms of the order dated such and such, passed by this court in the civil appeal. It is obvious that on the basis of the earlier order dated 16/5/24, the applicant shall not be evicted. This is the contempt matter the applicant is dispose of. Now, Lordship, thereafter, page 108, Lordship, you kindly see, we have given the association has given a representation. This is a detailed representation, Lordship. Page 111 of the representation, if you Lordship see internal page 4, the details have been given that in paragraph 5, that the state government is not complying with the other direction passed by the National Green Tribunal. Because what I have understood, Lordship, that in order to have a biogas plant or briquettes, the cow dung is very essential, Lordship. Now, in the meantime, they wanted to remove the khatal owners after verifying illegality, legality, and thereafter the government will take all steps within the month of March 2023, set up the biogas plant, set up the briquettes. They have to give the financial accommodation as per the suggestion and proposal by the Pollution Control Board, both West Bengal and Central. So we have given this in paragraph 5 of the representation. It was nothing was done, Lordship. Then in page 118, the Manoharpur again opposed the Supreme Court. Page 100, page 10, page 180, right? Kunta.
Application for direction. Manoharpur first went for the civil appeal.
That was the direction, correct. This is the contempt. I'm sorry. এটা কত নম্বর পেজ আছে বলো তো?
Application for direction.
The page
They passed an order on page 122.
Page 106, contempt.
No, that is for application for direction.
Direction, contempt का बोलो ना. 124. Order টা বলো. Order টা বলো. Lordship, just give me 1 minute, Lordship.
166.
166.
Yes.
Lordship, 166. Lordship, that order was for further direction. This is the contempt which was disposed of. The Supreme Court said that no case is made out to initiate contempt proceeding. With that observation, the contempt is disposed of. Now, if your Lordship see, thereafter, the Dankuni municipality passes an order of demolition, once again, page 122.
Yes.
এটা তো?
Yes.
Now see this order, Lordship, how this the municipality proceeds. In pursuance to the order passed by the Honorable Supreme Court of India on 3rd May 2024 in connection with miscellaneous application number such and such in civil appeal number, the applicant, that is representative of Manohar Milk Project Association, have appeared before the undersigned on 13th May 2024. The undersigned, in compliance with the order passed by the Honorable Supreme Court of India on 3rd May 2024 in connection with the miscellaneous application such and such, has heard the applicant, that is representative of Manohar Milk Project Association on same date at the office chamber of the undersigned. The representative of Manohar Milk Project Association have submitted their statement in the form of written application thereof, and thereafter the Dankuni proceed to demolish. Now the question is, Lordship, two things is there, Lordship. One is, Lordship, the direction passed by the National Game Tribunal not complied. I've suggested my client to approach the National Game Tribunal, because you have already, you can get yourself added as a party, because this that order is affecting is number one. Number two, Lordship, the Supreme Court said to give the observed hearing to all the affected parties. Now what they are saying,
go to the Supreme Court, sir.
Lordship, go to the Supreme Court. Lordship, I've advised them, because the NGT and Supreme Court, Lordship, they have to approach there. Even standing outside the court said that. But what is happening here? They have started demolishing as per the order. Now what they are doing, they are demolishing my structure there. It's my land. They could have removed my cattle shed. The question is whether I will be allowed to run the cattle shed or not. That is, at this juncture, the Dankuni municipality has right as per the order passed, because we have to go there for subsequent modification, whatever is there, vacating is there. But as of now, but what they are doing, they are removing my permanent structures there, my offices, my wall, number one. Number two, Lordship, there is a complaint, instruction of my client, that the local people, they are all stealing my articles there. There's no protection to my property. Lordship, what I suggest, whatever remaining sheds are there, we will also remove that. We will remove it as of now for this, and we'll take steps to go to the Supreme Court or National Game Tribunal as advised, as being advised, dear Lordship. But as of now, they cannot demolish those structures which are on my land. Structure they cannot demolish, Lordship. They can demolish cattle sheds.
Your structures are not legal structures.
That they have not decided, Lordship. What they have said, your cattle shed is illegal.
They are complying with the order passed by the
Lordship. They can do only thing, Lordship, because there is a very subtle things here. They cannot demolish my structure. They can demolish my cattle shed, Lordship. They can remove my cattle. They can remove my that big pot is there for foods, everything. They can remove my other temporary sheds there, so that I cannot keep my cattle there. I will not run the business of the cattle or milk industry as of now until I get the some result from the NGT or the Supreme Court, but they cannot remove the permanent structure from their lordship. This is my land. That is not the order, lordship. The order is for the removal of the cattle sheds or khatals. My office, my room, my boundary walls, everything has been broken. It is making a vacant land like a moidan. The purpose is that there should be no cattle, there should be no cow dung, so there can be no, I mean, the canal should not be silted. We will not do that, lordship. My clients are here. We will give in the undertaking, lordship. We will also remove within 3 days, lordship. All those which have any connection with the khatals, all the articles, we will remove that. But under the garb of removal of khatals, they cannot destroy my structure, lordship. It's my land, lordship. Lawfully purchased.
Yes, what else?
That is, lordship, only humble civil rest, lordship. Can you see they have made the entire thing is a Maidan, lordship. My permanent structure is gone.
Should be Maidan only.
I can do my any other business, lordship. Only Khatala may not run as of now until I get some relief from the National Green Tribunal. Government is not discharging their own duties which have been directed by the National Green Tribunal.
You have sanction plan for these?
We don't have a structure. The boundary wall is less than 9 feet. We don't require the sanction plan for that, lordship. As per the law.
Very good.
But they cannot
You're
demolish
talking about
my
boundary wall, you're talking about structures.
My boundary wall and 1 and 2 small room on the land. There's no G+2, 3 buildings not there.
So you can construct 1, 2 small rooms on the
Lordship, I'll just take instruction on 1 minute, lordship. Structure क्या बनता है? Teen shed and tile sheds are there, lordship. But the cattle are not kept in there. Like cattle have been kept in the temporary structure, lordship. We have removed the cattle from there.
Very good.
They are concerned that there should be no cattle there, so there should be no cow dungs. As of now, we have removed that. But my electric connection, they have disconnected.
Very good.
My water supply, they have disconnected. They cannot do so, lordship, under the garb of this order. They have to keep themselves confined to that I should remove the khatals.
Are you challenging your electricity connection here?
I'm sorry, lordship.
Are you challenging your electricity connection here?
No, we have not challenged, lordship. But the thing is that they cannot, lordship, they have got some limitation. We are challenging that they should not remove my permanent structure. They have a right to remove my khatals. Please remove it, or we will do it. We will go and cooperate. We'll do it, lordship.
All right.
In obedience to the order passed by the Honorable Supreme Court and the National Green Tribunal. But they should not destroy my livelihood, my property like that, lordship. I can opt for any other business.
Very good. Yes.
My lord, I think he has finished.
Done?
Yes, he is rightly thought so. I've done.
Anything more you can speak?
No. That is what I'm praying that I will remove, lordship. That is the undertaking we are giving. Within 3 days, lordship. But then they should not destroy the
I've heard you.
property, lordship.
Lord, I shall not take more than 10 minutes time. Lordship, kindly consider. First, my lord, what are the prayer? Prayer is regarding the consequential relief.
Yes.
That a read nature of mandamus directing the respondent to stay the impugn demolition work.
Yes.
I have gone through the other prayers. The prayer is not that stay or quashing of the order of demolition passed by the municipality in terms of the NGT as well as the Supreme Court. So that order remains. That order remains. This is consequential relief. When main prayer is not challenging the order, then no consequential relief can be granted. My first point. Now, my lord, kindly come to, lordship, that only, my lord, page 61, lordship, kindly come. Page 61, have you, lordship, got it, my lord? That is, my lord, the part of the direction given by the first order passed by the National Green Tribunal. This is very important. That is Roman 4. This Roman 4, that is, my lord, considered by the Supreme Court. Instead of, my lord, interfering with the other part of this order, Supreme Court, my lord, only considered this Roman 4 mentioned therein. Now, kindly consider what is Roman 4. We further direct that the state administration, Dankuni municipality, with the help of police authority.
We can read a better version.
Yes. I can read it, lordship. Shall remove the illegal cattle shed from the site expeditiously in accordance with law, preferably within a period of 6 months from 30th November 2023 and shall file an affidavit. This is the main controversy. Other, my lord, so far the suggestion, whatever the proposal, whatever the exchange therein or direction, other, that is, my lord, separate issue. This is not the writ petition for implementation of those, any of those. Now, my lord, kindly come to, my lord, this order was challenged by one association. He has never said that we belong to that association, never said. Now, association challenged that. This is their individual writ petition. Now, as when association challenged that, then, my lord, kindly come to, lordship, that 93. Only 1 or 2 page it is required. 93 is the order of Supreme Court after challenging that NGT order. Now, what Supreme Court said, as stated in the order dated 11 September 23, there is no reason to interfere with the direction contained in clause 4. That is the clause 4 directing for demolition of illegal cuttles and structure both. Paragraph 22 of the impugned judgment. However, while implementing the direction issued to the respondent number 10 and 11, show cause notice shall be served upon the persons likely to be affected by the demolition of illegal structures in terms of clause 4 of paragraph 22, and, my lord, pass the order by the municipality. Then, my lord, kindly come to one paragraph in the writ petition, paragraph number 3, Roman 6. What they have stated, paragraph number 3, Roman 6, that is, my lord, at page Roman 16, possibly. Roman 16, sorry, at page 16, at page 16. Roman 16, it is their averment. Your petitioners further state that the respondent number 8 and 9, that is the municipality, had issued so-called notices to the petitioners, amongst other cattle owners, pursuant to the direction given by the Honorable Supreme Court by its order dated 11th December 2023 in civil appeal number such and such. It is pertinent to mention here the respondent number 8 and 9 thereafter issued the demolition order dated 16th of February 2024 without considering the true merits of the matter at hand. So it is admitted fact, pursuant to order of the Honorable Supreme Court, show cause notices were issued, they were given the personal hearing, and then demolition order issued by the municipality on 16th of February 2024. So there it is not, now they cannot say that order of Supreme Court or NGT has not been complied with. Now, lordship, kindly come to page 105. Page 105.
Yes, that's the order of 16.
Order of the municipality, page 105. No, my lord, here is, my lord, certain, my lord, he has made some confusion. That is why page 105, I just want to draw your lordship's kind attention. 105 is the order of the municipality. It carries the date of 16th February 2024. This 16th February 2024 was never challenged. Before the Honorable Supreme Court, the order challenged by the association, that is of 2nd July 2024, which was passed by the municipality in respect of other cattle owners who may be belong to that association, and association took up the said issue to the Supreme Court, but not this order. So 16th February 2024 order remains. This order was not the, my lord, subject matter of the Honorable Supreme Court. Then, my lord, kindly come to, my lord, then what is our responsibility before the, my lord, the NGT? We are, my lord, very much concerned about the order of NGT at page 176. At page 176, this order passed by the National Green Tribunal starts at page 168. It starts at page 168. These order passed, or kindly, my lord, at the top, date of hearing 2nd July, and then suo motu. It is mentioned therein. For applicant, suo motu. Have you got it, my lord? At page 168, the last order of the National Green Tribunal in this matter, in this issue, page 168.
Yes.
My lord, kindly at the top, just below the, my lord, the quorum, for applicants, for applicant, suo motu.
Yes.
Suo motu was matter taken up that we are not taking any step in regard to that para 4. Roman 4 of that earlier order, parent order.
Yes.
In lordship, after considering all this affidavit and other thing, now, my lord, kindly come to 176. 176. Para 20, very important. Our position, Lordship, kindly concern the state's position, para 20. We may point out that prima facie, as of today, the state respondents are in gross contempt of the orders and directions of the Honorable Supreme Court. Then, my lord, the very important, we are inclined to transmit. We were inclined to transmit the record of this case to the Secretary General of the Honorable Supreme Court of India for being placed before the judges of the Honorable Supreme Court for initiating contempt proceedings for prima facie violation of the directions given by the Honorable Supreme Court. Since this tribunal is not vested with power of contempt under the National Green Tribunal Act 2010. However, Mr. Shivajyoti Chakraborty Learned Counsel and Mr. Saurodip Datta Learned Counsel earnestly pleaded that one more opportunity be given to the respondents for complying with the orders of the Honorable Supreme Court. However, considering that there is disobedience of the orders and directions of the Honorable Supreme Court by the state respondents, and each one is blaming the other, we refer the matter to the Chief Secretary Government of West Bengal to take appropriate action. Otherwise, this tribunal will be constrained to refer the matter to the Secretary General of Honorable Supreme Court of India for being placed before the judges of the Honorable Supreme Court. And then the last date mentioned therein, that is list on 1st September 2025, and we have to file the compliance report. At this juncture, they have come up before this Honorable Court and said that please to stay the demolition, but neither challenge the order, nor they have gone to the tribunal where the main order passed for any clarification or putting their stand therein. That very good. Let there be a distinction with regard to structure illegal, with regards to structure legal, or their ownership, what should remain and what should be demolished. These bifurcation of the order and interpretation of the order cannot be done in this way, because we are, my lord, compelled to, my lord, file their report that yes, it has been complied with. And practically, it has been complied with. That will be reflected in our report therein on the very last, my lord, the coming day, because it is entirely, my lord, demolition complete. So far the petitioners are concerned.
Yes.
So, my lord, my humble submission is this, my lord, in all respect, my lord,
we'll have it after lunch.
Yes, my lord, this petition is not maintainable. No order, sir.
That's right. After lunch.
Well, can I give only one line reply, Lordship?
Yes, after lunch. File chamber order.
I'm for the municipality in this matter.
Fine. Yes.
I'm for the municipality in this matter.
Yes.
Only two things, Lordship. One is that I was listening to the submission made by the state government. They were emphasizing that they have given the show cause which we have put in our application. But Lordship, there is a two part of the order. One is they will issue a show cause, will file a show cause. Second part is that they will be given a hearing to the affected parties. That is
Go
what
to
we
the Supreme Court, sir. You are aggrieved by that? Go to the Supreme Court.
Lordship, that
Any order which has not been complied, any direction of the Supreme Court, go to the Supreme Court.
Lordship, one thing more, Lordship, I will submit, Lordship, because
This court can't see that.
I can understand, Lordship, but only thing with Lordship, these poor illiterate people, this
They are not poor, sir, please.
no,
They are
no,
not
this
poor.
milk seller.
Milk seller are poor.
They are all having these cows and shutters. They are not so elite. No, they are not so literate people.
That I can accept.
Not poor in the sense.
Not poor.
Poor sense of.
Otherwise, you won't be here.
Lordship, one thing more, Lordship, I'd like to kindly appreciate, Lordship. My learned friend was emphasizing on the order passed by the National Green Tribunal, paragraph 4. The language is we further direct that the state administration.
Which page, sir?
Page 61, which is not very clear, Lordship. I was showing you the clear page.
Yes, yes, it's okay. I can read it.
Lordship, we come to page 150, 150.
Yes.
Just see, the language is we further direct the state administration, Dankuni municipality with the help of police shall remove all illegal khatals. So khatal has to be removed. But demolition of my structure or the wall and uprooting my property, that cannot be allowed. And we are ourselves submitting, and I'm with all responsibility with the instruction of my client, I'm saying that we will ourselves remove, Lordship. We will go to Supreme Court and NGT as advised, Lordship. But as of now, they cannot demolish they cannot make my property plain land. What they are apprehensive is, concern is that if I keep a cattle there, there is a cow dung, there will be a defecation, there will be a cow dung, there will be a silting of the canal. We have removed that. 70% people have already been gone there. I mean, their things have been demolished by entire thing. Remaining there, Lordship, my clients are there, have taken instruction. They will, today itself, will start removing whatever khatals connection is there, that big cemented tub is there, the temporary shed is there, the cattle's already been removed, Lordship. So there's no question of further polluting the canal. But this is my property. In the future, if I want to have some other setup of business or anything, they cannot, I mean, deprive
Nobody
me.
has taken your property, sir.
No, but they have demolished the entire, they have made a plain land.
They should.
Removal, Lordship, and demolition, if Lordship can be distinguished.
You challenge the order. Where have you challenged the order of 2nd of July?
Lordship, we have come for the first time because we were never the party in the proceeding.
All right.
I was not the party in the National Green Tribunal, Lordship. We were not there, Lordship. When they came with this demolition by miking, they have
do you have a sanction plan for any of the construction?
We have not done construction. We require sanction plan, Lordship. The boundary wall, Lordship, knows above 9 feet.
All right, sir. All right. Anything else? This you have already said.
We will remove the khatal, Lordship.
You have already said it.
Kindly with folded, Lordship. So many people. I mean.
Take down. The petitioners have filed the present writ petition seeking a writ of mandamus directing respond number 8 and 9 to stay the proposed demolition of the pakka structures erected on petitioner's land, as well as the land of the khatal owners. Full stop. The impugned action is being carried out pursuant to the demolition order dated 2/7/2024. Full stop. Although the petitioners have not, at this stage, directly challenged the said demolition order, they are nonetheless aggrieved by the same.
Lordship, with your Lordship, leave, Lordship. Can I conclude?
Full stop. The order, issued by respond number 8 and 9, declares the cattle sheds, khatals, operated by the petitioner to be illegal and directs that they shall be demolished. Directs that they be demolished. क्या लिखा है फिर से बोलो and dismantle direct कर दो को छोड़ and dismantle the structures associated with these illegal khatals. Illegal khatals be demolished. Full stop. The petitioner, who claims to be the lawful owners and operators of the said khatals, were instructed to cease operations were instructed to cease operation of the business associated with their khatals and remove the structure of these illegal khatals within 10 days, failing which the Dankuni municipality will initiate demolition action. Failing which the Dankuni municipality will initiate demolition action. Full stop. The petitioners are members of Manoharpur Milk Project Association and have been operating the said sheds from Dankuni municipality area for over 3 decades. Full stop. And original OA number 120. OA number 112/2022 was filed before the National Green Tribunal, Eastern Zone Bench, Calcutta, alleging that the DVC canal, also known as Dankuni Canal, in the Hooghly district of West Bengal, which is directly connected to the river Ganga, had been completely obstructed due to the regular discharge of cow dung from numerous cattle sheds in the vicinity. Full stop. The discharge has severely damaged / degraded the canal, rendering it dry and incapable of sustaining water flow. Full stop. By order dated 31/3/2023, the NGT disposed of the said application with a series of directions, including a direction to the state administration and Dankuni municipality to remove all illegal khatals / cow sheds from the site in question as expeditiously as possible, preferably within 6 weeks. Full stop. Pursuant to this, the respondent municipality issued removal notices by pasting them on the walls of the cattle sheds. Full stop. Agree by the said order dated 31/3/2023 of the National Green Tribunal, the Manoharpur Milk Project Association, preferred appeal number 5795 of 2023 before the Honorable Supreme Court. Full stop. Wide order dated 11/12/2023, the Honorable Supreme Court allowed the appeal by directing the respondent to pass a speaking order after affording an opportunity of hearing to the cattle shed owners. Full stop. ऐसे कर लेना. The wide order so and so, the Supreme Court modified the direction issued in clause 4 of para 22 of the impugn order by granting opportunity an opportunity of hearing to the cattle shed owners. Full stop. Subsequently, individual show cause notices were issued, and after granting the petitioner an opportunity of hearing, full stop, the respondent passed the impugn order dated 16/2/2024. Full stop. Thereafter, the association filed miscellaneous application number 778 of 2024 in civil appeal number 5795 of 2023. Full stop. The Honorable Supreme Court, wide order dated 3/5/2024, directed the respondent municipality to not evict the petitioners based on the order dated 16/2/2024, and once again directed the respondent municipality to pass a speaking order after granting an effective hearing to the cattle shed owners. Full stop. The court fixed 13/5/2024 as the date of such hearing. Full stop. In compliance thereof, the respondent municipality passed the impugned demolition order dated 2/7/2024. Full stop. Being aggrieved, the petitioner filed
2/7/2024 order in respect of that Manoharpur. So far they are concerned, their order already passed. They have not gone to the Supreme Court.
That's all right.
Their separate order passed in their case.
That's all right. There is no separate order which they have challenged, sir. Why are you unnecessarily creating confusion?
No separate order, sir.
Sir, please don't disturb.
Sorry.
Yeah. '24.
That's fine.
Being aggrieved, the petitioner filed contempt contempt petition, civil number 658 of 2024 in civil appeal number 5795 of 2023. Full stop. The Honorable Supreme Court, wide order dated 31/8/2024, dismissed the contempt petition, granting liberty to the petitioner to challenge the demolition order in accordance with law. Full stop. In the meantime, the National Green Tribunal took suo motu cognizance by registering miscellaneous application number 0525 in OA number 112 of 2022 and wide order dated what is the that suo motu?
2025.
No, no, page. 168.
168.
And wide order dated 2/7/2025, directed respond number 1 to 7 to file personal affidavits along with action taken report within 4 weeks. Full stop. The next date of hearing is fixed on 1/9/2025. Full stop. Anticipating imminent demolition, the petitioner has preferred the present writ petition. Writ petition seeking to challenge and prevent the demolition of their pakka structure, which they claim to have been pakka structure. Full stop. Next, learned counsel for the respondent contends that the present writ petition is not maintainable inasmuch as the petitioner has failed to directly assail the demolition order dated 2/7/2024. Full stop. It is submitted that the prayers made in the writ petition are merely consequential to the said demolition order, which remains unchallenged and has attained finality. Full stop. The respondent further argues that the demolition action is being strictly undertaken in accordance with law and in compliance with the binding directions by the Honorable National Green Tribunal as well as the Honorable Supreme Court. Full stop. It is therefore urged that no interference is warranted by this court at this stage, particularly when the petitioners have sought to circumvent the demolition order without questioning its legality or validity. Full stop. This court has heard the arguments advanced by the learned counsel for the parties and has perused the materials on record. Full stop. A careful perusal of the impugned demolition order dated 2/7/2024 reveals that it has been passed strictly in compliance with the directions issued by the Honorable Supreme Court in Civil Appeal number 5795 of 2023, wide order dated 3/5/2024. Full stop. The the Honorable Court had categorically mandated that a speaking order be passed by the respondent municipality after affording an effective hearing to the affected parties. Full stop. The records disclose that the petitioners, through their representatives of the Manoharpur Milk Project Association, were duly heard, and the authority passed a detailed, reasoned order upon consideration of their submissions. Full stop. The said order records that the petitioner failed to produce even the basic statutory documents required for running of cattle shed, such as cattle license certificate in Form 2 under Rule 3.5 of the West Bengal Cattle Rules, 1985. Consent to establish
petition as well, sir.
CTE bracket में and consent to operate CTO, groundwater related permission letter from SWID, ये पेज है 122, last paragraph. You can just mark कर रहा हूँ. To prove legality of these catals. Full stop. The इसको एक काम करना ना, ये तो कॉपी कर लो 122 ना, just last paragraph, just copy this, just copy it from here. Tick to take, huh? The petitioner made pakka construction without any necessary permissions from the competent authority. The petitioner admits that there is no, sanction plan or building plan for any of the construction on the above mentioned on the said land. Full stop. In the absence of these mandatory permissions is not a mere technical lapse, but constitute a direct violation of environmental, municipal, and public health laws, thereby rendering the operation of these cattle sheds patently illegal. Full stop. Moreover, these activities of these unlicensed cattle sheds have a direct and adverse impact on public interest, particularly on environmental integrity and right to a clean and healthy environment. Right to clean and healthy environment, right recognized under Article 21 of the Constitution of India. Full stop. The unregulated discharge of cow dung and animal waste into the Dankuni Canal has caused irreversible ecological degradation, comma, choking a once functional water body linked to the river Ganges. Degradation. Choking a once upon functional water body linked to the river Ganges, comma, and contributing to spread of waterborne diseases, comma, foul odor and public nuisance, full stop. The continued operation of the cattle sheds in densely populated areas without compliance with the health and sanitation regulations, comma, pose a serious threat to public health and hygiene, comma, especially for residents of the vicinity, full stop. Vicinity, the surrounding residents. Further, comma, the indiscriminate discharge of cow dung and other effluents directly into the Dankuni Canal, which is a natural water body connected to the river Ganga, comma, has resulted in substantial pollution and complete obstruction of water flow, full stop. The canal, which was once a navigable and ecological significant water course, now remains a choked and unusable water body, full stop. These facts were judicially acknowledged by the National Green Tribunal in its order dated 31/3/2023, comma, which found environmental degradation of a serious nature and directed remedial action, full stop. In a country grappling with rising urbanization and environmental stress, comma, municipal governance prioritizes ecological preservation and public health over unregulated private activity, full stop. The action of the respondent municipality, comma, therefore, are not in discharge, are in discharge of its statutory duty and are in furtherance of larger public good, full stop. This court cannot ignore the public interest dimension that underlines the present controversy, full stop. Allowing the petitioners to continue their operation despite proven illegality would not only defeat the rule of law, but also send a message that environmental violations can be regularized by misplaced equitable jurisdiction, full stop. It is tried that a person engaged in an activity that violates environmental laws, comma, municipal codes and public health norms can't invoke Article 226 to seek protection, full stop. Discretionary relief under Article 226 of the Constitution is available only to those who approach the court with clean hands and with respect to law, full stop. The petitioners have admitted that they have been operating the said cattle sheds for decades without even obtaining lawful permissions, thereby undermining both regulatory framework and the rights of public at large. Full stop. When the court queried from the petitioner, they conceded that no licenses or statutory approvals.
Trade license is there.
Cattle shed we are talking
No,
about.
trade is not there.
No license for running of the cattle shed or approvals were obtained or are presently held by the petitioner for running the said cattle sheds. Their continued occupation and operation of the premises is therefore illegal in the eyes of law, and their activities have contributed directly to the degradation of environment and public inconvenience. The presented petition is dismissed.
Careful.
Ah, 226 Constitution of India. Yes. 226.
Obliged, Lordship. The state government has done nothing. 2023 was direction upon them also. To set up the biogas and briquettes and everything, nothing.
That is for them. Challenge that order. Why didn't you challenge the demolition order? Who has stopped you from challenging the order? If you are aggrieved, go to the Supreme Court.
Advice.
You are not even challenging that order here also.
But the state government has got the duty to see their citizens also. They should provide the infrastructure.
Why you have not
Milk supply is the essential item.
filed it? Who's stopping you from filing it? At least file the right petition, sir.
Can there be a liberty to that effect in the order?
No liberty.
Grateful, Lordship.
Grateful, my lord.
Madam, my lord, I am
Item
appearing
number
on behalf of the Bali municipality, my lord. This is my affidavit in opposition, my lord, in the both the matter. My lord, there is a delay in our part to filing this, my lord. I am praying and an apology for that, my lord. This is the copy.
You have received it, sir?
They have stated that after filing this, they can receive.
Yes, Saurabh. Affidavit in opposition filed by respondent number. These are two matters, huh?
Yes, my lord.
Lordship. In 29, I am for the petitioner.
So in 28, this is 109. No, this is 10945. Affidavit in opposition filed on behalf of respondent number 2 and 3 is taken on record. Full stop. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the said affidavit in
Lordship,
opposition.
in 30, I am not the petitioner, Lordship. Only in 29.
In 29.
29.
All right, in 29, record this order.
And Lordship, I want
In
to
item
point,
30, who's there?
Lordship, they are the flat owners.
Anybody is there for the flat owners?
On the earlier occasion, they were appeared. And your Lordship directed them to file affidavit in opposition in item number 29, indicating that conversion of Doba into Bastu.
Sir, whatever it is, you go through the affidavit and
In no, not in for respondent 2 and 3.
In our record, my lord, there is no document which shows that there is a conversion, but there is a report. Earlier, they have filed a writ petition, and that writ petition court directed to file a report, and that report, it is the RI report. And the next occasion, my lord, I shall file the English translated copy of the RI report, which was filed by the BLLRO, my lord. In our record, there is a.
who is appearing for the state? No, I had only given and you are for the state. You were supposed to file affidavit.
The sum and substance of the BLR report is this, my lord, that they conducted an inspection and found that there is no water body, it's a solid land. As on the date of inspection, and there was no sign of recent filling up. That is what they found. Nothing more, nothing less. But their record of site, conversion was not done. But actually, in practical work, they found it to be filled up. This is one, my lord, and so far as our sanction, we have stated, my lord, that we do it on the basis of, my lord, the physical inspection and their, my lord, other documents.
Who's for the private respondent? They had sought time.
They are not appearing here.
Nobody is here for the private respondent. Yeah, you file your affidavit. Learned counsel for the respondent state seeks and is granted further time of 2 weeks to file her affidavit in opposition. 29. Item 29. This is 29, 10945. ये क्या 29 है? ये affidavit इसमें आया ना? तो इसमें ये क्यों लगा? अच्छा, ओके. None for the petitioner. There's nobody for the petitioner in this.
In 30, Lordship, the land flat owners are the petitioners.
None for the petitioner. Affidavit in opposition filed on behalf of respondent number 2, 3, and 4 is taken on record. Full stop. Let both the matters be listed. दोनों का साथ ही order है. After 6 weeks.
Lordship, 2 weeks. Your Lordship granted 2 weeks liberty to file opposition.
6 weeks. After 6 weeks.
So can it be after 4 weeks, Lordship?
9 September.
9 September. Much obliged.
Grateful to you, Lordship.
I have a division bench. Sorry? Yes. Item?
May I permit to mention my extension of time, my lord? I did not mention 33, my lord. Oh, sorry.
But I am on 34.
Sorry, sir. We'll take it some other time.
It will not be taken up today, but tomorrow, my lord, I have some personal difficulty because I was indisposed and hospitalized for a few days. So can it stand over to any other convenient date, my lord?
Or let's just ask your junior to be there.
My junior,
Any junior?
my junior is ill today. He hasn't come.
All right. Ask him to just mention that. He'll remind me.
Tomorrow, my lord.
At the risk of being reprimanded, my lord, item number 39. Tomorrow my interim order is expiring. My lord. I have already mentioned the matter, my lord.
Interim order
39,
expiring, 39.
My lord,
Keep it for tomorrow. Not today.
39.
my lord, item number 39,
Tila
my lord. My lord, Honorable Court directed me file affidavit. File affidavit is ready, my lord. Kindly fixed on Monday, my lord. Within 2 days, it will be affirmed and filed on Monday. My lord.
We will see that.
Tomorrow, Lordship, from March it is pending.
My lord, affidavit is ready. But the authority will come, my lord. Kindly Friday, my lord. Affirm this.
Whatever it is, sir, we'll see it. Rest of the matters tomorrow. Tension matter for tomorrow. We will see that tomorrow, sir. We are not taking any more. Tomorrow, sir. All right.
In this matter, I am appearing on behalf of the petitioner.
Yes.
So there is an application for substitution. That is CAN Milord 8937 of 2014. Date occurred Milord on 2nd of June 2014. Application has been filed on 4th of August 2014.
Application was filed on?
On Milord 4th of August 2014. 1-4. Or within 2 months or something. The department.
Substitution application has not been made. The substitution application one has to make, my lord, the legal only sole legal heirs, died intestate, sui juris, of unsound mind, sound mind. No such statement has been made, my lord. He has to file a proper application for substitution. Only the died intestate or not. One has to declare, my lord, died intestate or not.
That too, my lord, we don't have any function in the matter. It is the contempt matter. It is least between the court and the contemptor. We have to bring to the notice of the court how the order has been not complied with. We are not so vital part. We don't have any in the matter. Well, it is immaterial whether I have made that statement or not. My lord is to look into as to whether the order has been complied with or not. We are to brought to the notice of the court.
Mr.
only.
Manna, in what capacity are you seeking the substitution? In what capacity? As the wife?
My lord, I am the heir of the deceased.
The wife.
Wife.
What about the other heirs? Are you the sole surviving heir?
As per the scheme, heirs are not entitled. Only the wife is entitled to have the freedom fighters pension. And after her demise, only the unmarried, unemployed, widow or divorced daughters are.
But you are not.
I am the wife.
You are not seeking substitution on the basis of your right to claim the
area.
In the contempt, you are not seeking to be substituted as the person
in whose favor order was passed.
Person entitled to seek the
Freedom
pension,
fighter.
yes. Freedom fighters benefit.
Yes, sir.
No, you're not.
No. Because my husband filed the matter case for pension that was allowed. He was getting, then it was cancelled unilaterally. That was challenged by my husband. I don't know whether I have been clear myself. My husband was getting the pension.
No, we followed Mr. Man.
His pension was cancelled unilaterally. That was challenged by my husband in a writ application. Writ application kept the said order in abeyance. Against that order, my husband preferred an appeal. Appeal court passed the order as the trial court has kept the order of cancellation in abeyance. It obviously means they are to go on paying the freedom fighters' pension till the fresh order is passed by the authority. In spite of the same, nothing has been paid. Well, I have annexed the trial court's order, my lord, at page, my lord, 51, the starting, and my lord, your lordship will find at page number 54 and 55. That is that single court, single bench order. From second paragraph at 54. Well, shall I read? The decision that have been taken by the Union of India to revoke sanction of pension for these three freedom fighters shall remain in abeyance till such time as indicated hereafter. The petitioner shall be granted opportunity to post decisional hearing within a month from date due to old age if it is not possible for the surviving freedom fighters or the petitioner in WP number such and such to attend the hearing. The union shall allow them to represent by their respective learned advocate. This was the order of the trial court.
Page 59.
And then, my lord, your lordship can take pen to, my lord, page 59.
What was the speaking order which has been passed by the, because there was a complaint against the husband,
Yes, sir.
and on the basis of the complaint, you had stopped his pension.
Yeah. And I have got the instruction, I shall satisfy your lordship also on merit. And what happened, after the division bench passed order by the division bench, it was incumbent upon the authority to give hearing and to pass an order.
Yes.
That notice was served. He did not appear. He, repeated notice served. I have got written instruction. If I go on merit, this contempt application liable to be dismissed with cause, subject to And your lordship kindly take my request.
You have the notices which you had given to send to him.
That is this is my written instruction.
I don't have that instruction. If that be so, there must be some reason order passed by my learned friend's client.
So, reason order will be called only if you have participated. If you have not participated,
If I do not participate, for argumentation, well, the notice was served on my client. No, I did not participate. Then obviously some order will be passed by them, either rejecting or allowing. Some order must be passed by the authority. Let them produce that order that they have passed. Until that date, I am entitled to have that pension. Till disposal of that representation, I am entitled as per the...
That representation was made by the freedom fighter himself. That is your husband. It was made by the husband.
Yes. It was sanctioned in favor of my husband long back in 1989. Subsequently, unilaterally, that pension was revoked by the authority concerned. I challenge that.
So when you say I means the husband.
My husband.
Right. That's
sorry,
what I'm saying.
I'm sorry.
No, that's all.
My husband challenged that application before the Writ Appellate Court.
Right.
Writ Court kept the order, kept in abeyance, and directed to take decision on after hearing the matter. I prefer an appeal. In the appeal court, the division bench said, till such hearing is done and order is passed, as the order impugned has been kept in abeyance, it means you are to go on paying the freedom fighters' pensions. My case is, if my learned friend gave a notice, let us assume he gave a notice to us or to my client did not appear, then obviously they might have passed the order against me. Till that date of passing of the order, as per division bench order, I am entitled to have the pension. Well, I am on that point only. Let my learned friend show that till that day he has paid. Otherwise, my lord, I according to my understanding, the court's order has been violated. So I am to, my lord, brought it to the notice of my lord that by this way they have violated the order. I got a very limited scope to argue before my lord. My lord is to see whether my lord's order has been complied to or not. But shall I place 64, 59 for a moment, my lord? 59. However, as the learned single judge has ordered, page 59 of the contempt application, order to keep the order of revocation of sanction of pension in abeyance. Obviously, the consequence to keep the same in abeyance have to be followed, meaning thereby the freedom fighters' pension shall be continued till fresh order is passed after hearing the writ petitioner appellant in accordance with law. I'm here only. Let them show that the order has been passed on this date, and till that date I have paid the freedom fighters' pension. And if my learned friend show that, I will be out of court.
Given a show cause notice.
দাঁড়া, আস্তে আস্তে। দেখে তো কি হবে, আগে দিয়ে তো টাকা দেবে, ওরা তুমি যাবে পাস করা করবে, তোমার ওরা ভাইরাস হয়েছে কোনো হুজুর দেখবে।
You file your affidavit.
Before that, one of the substitution application to be allowed, your lordship kindly allow the appeal is to
We
be,
will consider the substitution application. You file your affidavit.
and we will file opposition to the contempt application.
Contempt
As-
application.
as you-
Both the take down. Learned counsel for the respondent seeks and is
ঠিক
granted.
আছে, ঠিক আছে।
How much time? Esther,
কতদিন টাইম আছে?
how much time?
6 weeks.
6 weeks?
6.
Why 6 weeks?
And we have to draft it, send it, they've hate it, my lord, thereafter, my lord.
4 weeks, 4 weeks. 4 weeks to file affidavit in opposition. As well as affidavit in
এটা
opposition
উচিত
to
হবে,
the contempt
উচিত হবে না,
application.
এগ্রিমেন্ট চাইলে ওটা দিচ্ছে তো।
Affidavit in opposition to the main writ petition. Writ petition number so and so. Affidavit in opposition to the contempt application. Reply to the same if any within 1 week thereafter, list after 6 months.
One, well, can I pay for one more indulgence? Well, in the meantime, if they show desire, they may comply with the order. My lord, kindly have it.
Nothing. Let it come.
As you know, I am to pay before my lord.
Let it come.
Let them. 9 September.
और भी है? और है? कौन सा?
Same
order.
Same order. 2 and 3.
Two and
Deep obligement. Deep obligement.
1, 2, and 3.
Yes.
Well, as 2 and 3 did not call why I am standing here.
No, no.
Deep obligement.
Material instruction.
Deep obligement.
What is for?
This is the contempt matter appear first time. And the lordships kindly see your lordship's order in the division bench modified to that extent the subdivision officer directed as per provision of the act. That
Where's the order?
lordships page 49 onwards. And the operating portion I drawing lordship's attention page paragraph 10 to 12. Page 52 and 50 and 52. This is relating to the unauthorized construction. Panchayat has taken the decision, but the demolition was not carried out as per provision of the act. Subdivision officer is the sole authority to execution of the order, and that's why division bench by lordships passed an order up to the subdivision officer under section 200 Section 22(5).
23(5).
23(5), sorry. 23(5). That is indicated paragraph 9 also.
What is the contempt that you are alleging?
It is a contempt application.
What is the contempt? What is the contempt that you are alleging?
Contempt in spite of communication. This appeal was arises by the other side. I am the writ petitioner respondent in the appeal, but the appeal is carried on other sides relating to the demo.
What is the contempt that you are alleging? There are two parts to the order.
That order, that
To see the order.
yes, there is paragraph
The order
14.
in contempt is of
Paragraph 14.
Order in contempt is of 11 September 2024. There are
Then
two
your
parts.
notice come to the time bound is the paragraph 14 within 2 months from the date of communication of this order.
So what is your, no, there are two parts to the orders. First is that we will pass a reasoned order after giving an opportunity of hearing. And the second is there's an order of status quo which will be clarified by the appellate court.
In the civil court. In the civil court.
No, says appellate court.
Appellate court means civil court. This is
For the
the
district judge.
This is the district judge.
13 is
I
not in,
am to that extent I am not
13 is not in paragraph 13, not in contention. Your contention is 11 and 14.
14.
Did they give you a notice?
Yes,
for hearing?
Yes.
And hearing was done?
Nothing has been done. Paragraph page 54.
50?
54. Page 54.
Yes.
And thereafter page 58.
No, did the subdivisional officer give you a notice for hearing?
Nothing. Nothing has been taken step for comply the order. The facts remains, my lord, the Panchayat authority decided to unauthorized construction.
Demolition of an unauthorized construction. After giving you a 23(5) hearing, notice hearing and a reasoned order.
No, my lord, the question arises, the Panchayat authority take the decision, the unauthorized construction,
Pradhan will
but the
take a decision.
demolition could not be done. The provision 23(5).
11 and 14. 14, paragraph 11, opportunity of hearing, pass appropriate orders in accordance with law. Read with 14, shall pass the necessary orders within 2 months from the date of communication. Now, saying that no notice has been given, no opportunity of hearing. Contempt. And
But then hearing the order.
Let us ask them to serve.
Pass necessary orders.
Rule or come to serve.
Come to servant. Have you served the other side?
No, no. I have not served. Your lordship's direction we given to serve them, please. This is the first time come before lordships.
All right. Take down. The petitioner has filed the present contempt petition alleging non-compliance of the order dated
July. 11 September.
11 September 2024. Full stop. Learned counsel for the petitioner states that the directions which were issued by this court by the above mentioned order has not been complied with. Full stop. Let learned counsel for the petitioner is directed to issue a notice on the respondent. Let this matter be listed on such and such, along with the copy of the contempt petition. Let this matter be listed on. Give a date. You'll give a date.
No. Who will be served? What a This Manjeet Kumar Yadav is still the SDO. No change in
Has yet been.
of the contempt.
A copy of the contempt petition shall be served upon the respondent contender. Full stop. Let this matter be listed on such and such. Serve a copy, we'll see.
Will
what
it
they
be
have.
listed on? It will be listed on.
How long will it take for you to serve?
No, I saw the notice.
How long will it take for you to serve the notice?
Only 3 weeks.
3 weeks.
No, 3 weeks. No, service time immediately calculate kore.
3 weeks. Just check after 26th August.
26 छुट्टी है ना? ओ हम 24 वाला कैलेंडर यहाँ पे
I don't know. That is we are afraid of.
So that's why we'll have it on 26th August. You are the one who's asking for 3 weeks time.
No, that is when service effective service should be done. We serve the notice by speed post. That should return back. Or
It takes 1 week, sir.
I have no objection to that.
You are making both
Tomorrow I serve the notice. But it is generally 15 days, my lord.
You can serve it by hand also, sir. You can send somebody.
My lord, I think, my lord, the hand service will not be accepted by seeing the contempt application.
All right. So when do you want it? 26th August?
26th August.
29th August.
Yes, madam.
29th August.
Yes, madam. 29th.
3 p.m.
March 3
p.m. 29th.